Tech support, you ready on your end?
Yes, Chairman, we are.
Okay. Good morning, everyone. Welcome to the July 17th virtual meeting of the Zoning Board of Appeals. First, I'd like to take judicial notice of the fact that on June 26, 2020, the governor of the state of Illinois signed a disaster proclamation declaring all counties of the state of Illinois a disaster area due to the COVID-19 public health emergency. This disaster proclamation is in effect until July 26, 2020, and thus Section 7E1 of the Open Meetings Act has been met. Second, I am making a determination pursuant to Section 7E2 of the Open Meetings Act that an in-person meeting of this board is not practical or prudent. Similarly, I am also making a determination pursuant to Section 7E5 that because of the disaster declared by the governor, it is unfeasible for at least one member of the Zoning Board of Appeals or its chief administrative officer or its chief legal officer to be physically present at the meeting place, inasmuch as there is no physical meeting place. Third, this meeting will operate under the board's emergency rules governing the conduct of remote public board meetings and provisions for remote public participation, which are posted on the board's website. I encourage everyone who frequently appears before the board to familiarize yourselves with these emergency rules, as we do not know how long the COVID-19 public health emergency will last. In line with the emergency rules, today's meeting of the Zoning Board of Appeals is a virtual meeting that is being simulcast to the general public via live stream. It is also being recorded. We've established these virtual hearings in keeping with the governor, General Assembly, Mayor, and City Council's goal to continue the government's functions while maintaining transparency and public safety. But there are technical limitations to this format that we must collectively manage, particularly with respect to the presentation of new evidence during a hearing and the ability for applicants and objectors to resolve objections or amend proposals during our hearing. As a result, any material to be presented to the board, whether by applicants or members of the public, was required to be submitted in advance of this meeting. And in addition, everyone wishing to testify at today's hearing, whether on behalf of an applicant or an opposition, was required to register before today's meeting. For those who do not regularly appear before the board, I will go over a few things for those who are participating in the meeting. Number one, as I said, we are operating under the emergency rules. So for all applicants, objectors, and attorneys, if you did not send us your exhibits by the cutoff date and time, you will not be able to reference them in today's hearing. 2, all participants will be listed as attendees within this Zoom meeting until your matter is called. At that time, we will transfer you into a panelist role. There will be a short switchover where you will lose the feed, so don't be surprised by that. Third, once you are set as a panelist, you'll present your case. Board staff will be presenting the PowerPoint exhibits for everyone as we normally do, so you will not need to manage sharing your screen. Fourth, please be mindful of background noise and please mute yourself when you are not speaking. Fifth, please note that we have a court reporter preparing our record, so it is important that two people not speak at the same time. You might see me muting somebody if that's happening. 6, if you are an active participant in this meeting, please do not watch the live stream. This will cause audio interference. I'll repeat that. If you're an active participant in this meeting, please do not watch the live stream in tandem. 7th, please make sure you identify yourself whenever you are speaking. This goes for attorneys, applicants, members of the public, and board commissioners. Since all of us are remote, we and our court reporters cannot always see who is talking at any given time. I will be administering the oaths for each witness individually as a result. 8, if an applicant or anyone in opposition to the application has any technical issues presenting their case and is unable to proceed, we will attempt to continue the matter until the end of today's call to create time to resolve whatever those technical issues are. If unsuccessful, we'll continue the matter until a subsequent meeting. 9, after your matter or matters are concluded, please feel free to leave the Zoom meeting. If you're interested in continuing to watch the meeting, I encourage you to watch it on the live stream, which is accessible from the board's website. Now, I'd like to call this virtual meeting of the Zoning Board of Appeals to order. I will take a roll call vote to establish quorum. Commissioners, after I call your name and you state that you are present, please verify that you can hear and see me. Commissioner Garcia.
Hi, I can hear and see you.
Commissioner Saul.
I can hear you.
Commissioner Esposito.
Here, and I can hear and see you.
Commissioner Toya.
Here, and I can see you and hear you as well.
I am present and can only partially hear and see myself, but nevertheless, quorum is established. The minutes of June 26, 2020 meeting have been distributed. Unless there are corrections, I move that we approve the minutes as distributed. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I also vote yes, that matter is confirmed. Next, I move that we approve today's agenda. Commissioner Toya seconds, Commissioner Garcia.
Yes.
Commissioner Saul,
Yes.
Commissioner Esposito,
Yes.
Commissioner Toya.
Yes.
I also vote yes, and that matter is approved. I'm going to skip my my regular general announcements and trust that the attorneys who frequently represent applicants before the board have read our latest updates to our regular rules that we made last month and have downloaded our updated findings of fact forms for variations in cannabis special uses, as well as our updated cannabis affidavits. For those of you who haven't, everything can be found on the board's website at chicago.gov/ZBA. Next, I know we have some requests for continuances, especially for board calendar number 15220S. Before I get to those requests, I want to speak to a few misconceptions I've heard regarding my May 15th, 2020 continuance of that board calendar number 15220S. May 15th, 2020 was the first time in the board's 97-year history that it held a virtual meeting. At that time, we, like other boards and commissions within the city and throughout the state, were unsure if we had the technological capacity to hold virtual meetings that would allow the public to participate as fully as they do in physical meetings. Therefore, for controversial cases such as 15220S, I decided it would be best if we delayed until such time as 1, the board could resume in-person hearings, or 2, I felt that the virtual hearing format was sufficient to accommodate everyone that wished to comment on controversial matters. Therefore, on April 28th, 2020, the day we formally rescheduled our March 20th meeting to May 15th, 2020, I had the board secretary update the website to state that the board would not hear 15220S at its May 15th, 2020 hearing. This was to ensure that as many people as possible received advance notice that we would not be hearing the matter on May 15th, 2020. At that May 15th meeting, I stated, and my statement can be viewed along with the rest of the May 15th meeting archived on the Department of Planning and Development's YouTube page, that the matter would be continued again until either 1, the board could resume in-person hearings, or 2, I felt that the virtual hearing format was sufficient to accommodate everyone that wished to speak on the matter. Since that time, the board has held 3 successful virtual meetings under our emergency rules. Members of the public have timely signed up to testify on matters at our prior virtual meetings and have been able to address the board in real time via internet video conference or by phone. We have also received clear direction from both the General Assembly and the governor in the form of the latest amendment to the Open Meetings Act on how to ensure that virtual meetings remain open and accessible to the public. Based on these factors, I believe that the virtual format is sufficient to accommodate everyone that wishes to speak on controversial matters such as 15220S. So while I am willing to entertain a request for continuance, I will not be continuing 15220S solely on the basis that a virtual format is not conducive to hearing the matter. And when the board does hear the matter, whether that's today or at some future meeting, I want to be sure that everyone in attendance here today understands how the hearing will proceed. I think it's important to emphasize that what we are all here for. This is not a town hall meeting. This is a meeting of the Zoning Board of Appeals. The board is not a court of original jurisdiction, and it is not a legislative body. We have a very specific regulatory framework in which we have to operate. Therefore, while everyone that is signed up to testify for 15220S is welcome to give testimony, that testimony must fit inside of that regulatory framework. What do I mean by this? The law requires that the applicant for 15220S prove to the board that its application meets the special use criteria set forth in section 17130905A of the Chicago zoning ordinance. The criteria should be up on the screen, if we can share that, and I encourage all of you to review it. It can also be found in chapter 17 of the city's municipal code, which is available online. As you can see, there are 5 criteria that the applicant must prove. These are the only 5 criteria the board can consider when making a decision. And therefore, any testimony given during the hearing on 15220S needs to be relevant to these 5 criteria. Further, these 5 criteria do not exist in the abstract. We also have an overlay of state and local laws that limit what we can hear. What do I mean by this? I mean that we will not accept testimony that is outside of our jurisdiction. For instance, we will not accept testimony about whether legalization of cannabis is a good idea. The state of Illinois has previously determined that it is in the interest of health and public safety for cannabis to be a legal substance that is regulated and taxed like alcohol, and we have no power to overturn the state's determination. We will not accept testimony regarding the sufficiency of the applicant's social equity obligations either. The state has previously determined what the applicant must do to obtain a state license, and this includes a social equity component. Again, we have no power to overturn the state's determination in that regard. So please do not ask the board to consider any community benefits agreements or argue that the application must be denied because the applicant does not, to your satisfaction, provide enough social equity. We will also not accept any testimony about whether cannabis should be sold within the city. City Council has previously determined that it can be sold within the city and that it can be sold starting January 1st, 2020, and we have no authority to overturn the City Council's determination. Note also that as the applicant held its community meeting prior to March 20th, 2020, the supplemental rule that the board issued last meeting regarding community meetings during the current pandemic is not applicable to this application. I want to be clear that there may be other instances in which I determine that testimony is not relevant to the criteria or that we are prevented from hearing the testimony due to state or local law. When that happens, I will conclude that person's testimony. For example, City Council has determined that a cannabis dispensary cannot be located within 500 feet of a school. However, anything outside of that 500-foot boundary, no matter how slight, is legal and permissible. Therefore, it is not enough to state that you feel that the applicant's proposed dispensary is too close to a school. You must instead explain how this proximity to a school means that the applicant does not meet one or more of the 5 criteria up on the screen and that we have to consider. Along those same lines, neither the state of Illinois nor City Council has imposed any restrictions regarding a cannabis dispensary's proximity to a park. This is in line with the state's finding that cannabis should be regulated like alcohol. In the city, there are many instances of alcohol being sold in proximity to or even in parks. So again, it's not enough to state that you feel the applicant's proposed dispensary is too close to a park. You must instead explain how this proximity to a park means that the applicant does not meet one or more of the 5 criteria we can consider in our review. This gets me to the next announcement, which is how this hearing will proceed. Again, it's not a town hall. When we call 15220S, the applicant will go first and put on all of its witnesses in its case. After the applicant has done so, any members of the public that have signed up to speak in support of the application will testify. After the members of the public in support make their statements, I will go immediately to the objectors who are represented by counsel. Those objectors can cross-examine any of the applicant's witnesses and put on all of their witnesses. After that, any unrepresented objectors can testify as well as cross-examine the applicant's witnesses. After that, I will return to the applicant for its rebuttal, at which point the applicant can cross-examine any of the objectors and their witnesses, as well as put its witnesses back on for any rebuttal testimony. If the alderman would like to make a statement, he or his representative may choose whether that is immediately after the applicant's presentation or later on in the testimony. Throughout this process, the board asks any questions that we may have of the applicant or of any of the witnesses involved. And after that, the board takes the matter under advisement. Please make sure you state your name and address prior to providing any testimony. In order to ensure that everyone is heard, please do not repeat testimony. For example, if you are against an application because you believe it will increase traffic in the area and someone else has already testified to that effect, please just testify that you agree with the prior testimony regarding increased traffic. If your testimony is repetitive, I'll conclude that testimony as well. So with that, let's hear the requests for the continuance of 15220S. Tech support, let's promote, if we haven't already, Alderman Hopkins, Mr. Gene Murphy, and Ms. Katrina McGuire. I'm going to ask Alderman Hopkins to make his request for continuance first, and then I will go to the applicant to confirm that the applicant wants to object to that continuance. And if so, I will ask Mr. Murphy to present his request for continuance after the aldermans, and then Ms. McGuire will have you present your objection.
Thank you, Mr. Chairman. I appreciate the very thorough outline of the process. And that is something that I believe many of the public members will find instructive and useful and also new. I have quite a few members of my community that I've been in contact with in the preceding weeks who are new to the ZBA process and also to this format. And I happen to agree with you, Mr. Chairman, that despite whatever limitations there may be utilizing a virtual format, we can still make all the proper decisions that we in government and in regulatory bodies need to make. So it need not be a barrier. However, having said that, it has been a barrier, and I'm not pointing the finger of blame certainly at this body. There's a variety of reasons, perhaps for each individual person who has contacted me and expressed frustration that they were unable, either due to technical problems or other issues, were unable to participate in this process up until now to their satisfaction. And because this is such a high visibility decision that needs to be made, and there are strong opinions on both sides, in order to satisfy the continuing demand for additional public participation, I'm asking for this deferral now. I've been in touch with representatives of the applicant this morning. They have no objection to my deferral request, and I'm speaking for the company only, not the property owner. They have no objection to my request for a deferral. I understand there's other requests that have been submitted independent of my office for a deferral. I can only speak for myself. My intention in seeking this deferral, again, is to allow the active members of my neighborhood, the neighborhood leaders, the other stakeholders who have expressed their desire to continue to have their voices heard and to work in good faith with the applicant. They've indicated to me they will work in good faith through an additional public hearing process, however it turns out in the coming weeks. So for that reason, I would respectfully ask for a deferral of this matter to the next ZBA meeting. Thank you.
Thank you, Alderman. Ms. McGuire, I would like to get you on record whether you're okay with that 1 month continuance or whether you'd like to object.
Good morning. Yeah, for the record, Katrina McGuire, counsel for the applicant. Look, I guess our point here is this, that we have been waiting for 4 months to be heard. We certainly would vehemently object to any requests on the part of the objectors. To the extent this board is inclined to grant Alderman Hopkins' request for continuance, we would certainly ask this board to consider entertaining a special meeting that could be held less than a month from now to ensure that any conversations that we would have or be requested to have with neighbors, which we've always been willing to do, be productive and could happen expeditiously.
Thank you. Mr. Murphy, do you have anything you'd like to add, or do you want to, I believe your original request for continuance was until September. Would you like to make any motion on that front or make any request?
Yes, Chairman, thank you very much. And I will say this as my first time before your board. Thanks for the outline. You know, for those of us new to the process, it was very helpful. I obviously want to thank Petitioners Council for cooperating with the aldermen, and I look forward to their cooperation with the neighborhood. With respect to the continuance, these are unprecedented times. And Chairman, I understand that this is not a town hall meeting, but it is an administrative process that is to guarantee due process to those most affected by the decisions. That would be the citizens who live in the immediate area, which include business owners, restaurant owners, and children going to and coming from school. It's the protection of the process that we need to worry about here. And I have been doing a lot of these Zoom hearings and trying to do Zoom trials. They just don't work yet. We're not there yet. And quite frankly, we have a governor and a mayor who are both very concerned, and they said it most recently, of the recent spikes in the COVID. And I did love the mayor's comment that she would not only stop the car, but kick the kids out. And that makes a lot of sense to us, especially those of us who are parents. But at the end of the day, there are serious concerns about meeting in public. And this subject matter is very special, as you have recognized and as the board has recognized. No disrespect to any other issues, but this is a hot topic. And because it is a hot topic, I believe the process needs to be protected. And that process is an ability for not only objectors, but those who are in support of the project, both, to have an opportunity to be heard in a way that they can be heard, in an effective way that can be heard. And that is not by Zoom call. And we have seen just on this call today that was supposed to start at 9 o'clock, there was no way this was starting at 9 o'clock because of the number of people who have tried to get on. My phones here in my law firm are absolutely lit up with neighbors trying to get on this. Now, I don't know why they can't get on it. And believe me, I am not the IT person at my firm, but I know that that we can do better, that the process can be protected, the due process to the citizens can be protected. And Mr. Chairman and the board, I would request that this matter be continued until such time that we can meet in person. Now, I appreciate opposing counsel's position that they've been waiting for 4 months. Well, the country has been waiting 4 months for a lot of things. council has not put forth to you, Chairman, or the board, any undue prejudice to her client. They are the only game in town with respect to an application. The competing application was withdrawn. There is no emergency here. There is no fast track necessity here because they are the only applicants in the area. And they have not shown any undue prejudice to their clients other than they want to get started. And I don't dismiss that. Believe me, I represent a lot of business owners. Everybody wants to get started, but the process by which we get started needs to be protected. So, Your Honor, in conclusion, and thank you very much for your time. I apologize for the rambling, that we ask for this matter to be continued until such time that we can all meet in person, vet this subject matter properly. And I will say also give myself an opportunity with Ms. McGuire and the alderman to work together to maybe find some common ground where the matter can move forward cooperatively as opposed to as antagonistically as it's been thus far. And thank you, Mr. Chairman.
Thank you, Counselor. Ms. McGuire, if you want to respond to that, go ahead.
I won't belabor it. I mean, Mr. Chairman, you made it very clear at the outset in your rules that you were not going to entertain continuances on the basis that the virtual format is not sufficient. So I'm not going to belabor that issue. I think as far as prejudice to my client, simply the fact that there's no competing dispensary application within 1,500 feet does not mean that we have not been waiting patiently for 4 months. We've made investments in this property. We have every right to proceed to a hearing, and it has been determined that these hearings can be held effectively. That's your own determination, Mr. Chairman. We've always been available and willing. We have reached out to Mr. Hyde's client many months ago to try to have meetings. Those conversations and requests have happened repeatedly throughout this time and have never been entertained, not even responded to. So to the extent that we're happy to have agreement on these issues, but we don't believe that we're going to get there very quickly. We believe this matter should be heard today. And to the extent, again, that I would reiterate that to the alderman's request, to the extent the ZBA is inclined to grant it, we would ask that the ZBA consider a special meeting, which in my humble opinion, would perhaps help facilitate the process in this virtual setting as well. Thank you.
Thank you. Okay, we are going to continue this matter for 1 month until our August 21st meeting. I have a couple things I want to just flag for everybody. One, to Mr. Murphy, your point, I will just reiterate that my comments earlier about virtual meeting format, I think while I appreciate your concern about protecting the process, I think given the open-ended nature of this pandemic, it's a question of protecting the process versus ending it all together, because we're not going to be doing in-person meetings anytime soon. So we're going to continue this until August 21st. That is there will be no further notice. Okay, so for everybody who wants to participate, you're not going to get any more mail on this subject from the applicant, et cetera, for notice. It'll be August 21st. I want everybody to just be aware, if you want to participate in this meeting, you need to sign up as either an objector or a supporter in advance. There will be a deadline. I think we've set it at about 4 or 5 days in advance of the hearing date. So this will be in advance of August 21st, by which if you have not signed up with the board's staff, you can find all this information on the board's website. If you have not signed up in advance, you cannot participate or log into this meeting. So for the list of those folks who are calling Mr. Murphy, trying to get in, I want to make sure that you've actually registered. So you have an extra month to do that. You do need to do that to participate. Otherwise, you can always submit written testimony, and we have that in our record, and we do review that as part of the case. But if you would like to sign into the Zoom meeting as a participant, you need to register in advance. Everyone else can observe it, obviously, on our live stream. I want everyone in attendance to use the 1 month continuance to consider how your opposition or support for this application fits within the 5 criteria that we laid out, so we can have a productive hearing on this matter on August 21st. I know there's been some sentiment expressed to board staff that this board has already made up its mind about the application or plans to decide 15220S based on something other than the criteria set forth in section 17130905A. So I want to be clear, when we hear this matter, the board will decide, as it does on every matter before it, to grant or deny solely on the basis of whether or not the application meets the criteria set forth in the Chicago zoning ordinance. It's 5 p.m., by the way. It's the Monday before the hearing. So 5 p.m. the Monday before August 21st is our deadline for you to submit your request to participate as an objector or a supporter. So we're going to continue this matter again, August 21st. Everybody who is signed in right now for this Zoom meeting, for that matter, I encourage you to sign out and to continue watching on the live stream. We will have some matters later on in today's hearing that are contested, so you can get a better sense of seeing that process that I outlined actually in practice. Okay,
Mr. Chairman,
go ahead, Counselor.
may I just make one point? Could we just have for the record clear that to the extent the objectors are going to be submitting any additional witnesses or evidence and exhibits and witnesses, that we reserve the right to supplement our submittals as well?
Yes, and so the same thing applies for applicants, right? You have a deadline by which you need to provide any other material that you want to provide, and that's the whole purpose, part of the purpose of why we have everybody register in advance, is so we can make sure everybody sees everybody's material. That is the most significant technological limitation of this platform, is we can't just share things with people while we're live. So everybody needs to be registered. Everybody, whatever it is you want to present, needs to be sent to us in advance, so we have time for everybody to see each other's new materials and there's no surprise during the hearing itself. Okay, next I'm going to take our other requests for continuances.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you, everybody. So the next one I have up is 19920Z. I believe Alderman Thompson is requesting a continuance on that matter.
That is correct, Chairman. And I will make other continuance requests on behalf of the department.
Do we know, is anybody from the Alderman's office here to speak on that matter?
No, they only sent a letter, and the attorney had spoke to the alderman, and they agreed to the continuance.
Okay, so we'll continue that one until August 21st. And again, no further notice will be given. August 21st, this is 19920Z at 2716 South Emerald Avenue.
And then, Mr. Chairman, on behalf of the department, case number 23420S on page 3, 2423 South State Street. They had a review, and it was determined that they needed an additional special use, so they're in the process of filing that. The department asked for the 1-month continuance for them so that they can submit the other application. And the attorney is present. It's Rolando Acosta.
Counselor, can we just promote him? I just want to get him on the record. There's no objection.
Go ahead, Rolando.
Good morning, Mr. Chairman, members of the board. We have no objection to the 1-month continuance.
Okay, so that's 23420S will be continued until August 21st, and no further notice will be given. Thank you, Counselor.
And then, Chairman, on same page, number 23620S and 23720Z, on behalf of the department again, we're requesting a continuance. They were working out some design reviews, and they're working with the department to address any issues that the department needs to be addressed.
And do you know if we have anyone from the applicant here?
It's Paul Kopex, the attorney.
Okay.
But he was notified and did not have an issue.
Can we just have him confirm that fact on our record?
I don't believe he signed in.
Okay. Then we're going to continue 23620S and 23720Z until August 21st. And again, no further notice will be given.
And then again, Chairman, on page 3, number 23920Z, the attorney is Mark Kupiak and Agnes Pleka. This was part of a type 1 rezoning. They have since changed their design, and Agnes can speak to this, but the department is asking that they continue this matter so that they can address any zoning issues in regards to the redesign. Agnes has been promoted, so if you have questions, you can ask her.
Sure. Counselor, can you go ahead and just let us know your thoughts?
Good morning, Mr. Chairman, members of the board. My name is Agnes Pleka. I'm one of the attorneys for the applicant. We do not have objection to department's request for continuance for 1 month. The applicant has revised the plan slightly. We still need exactly the same relief from the board in terms of the rear setback. However, the zoning department is still reviewing the design changes in connection with the prior zoning change. So that's where we are.
Got it. Okay, so we will continue 23920Z until August 21st. And again, no further notice will be given.
Thank you.
Thank you. Okay, let's continue in our regular course of business. First up, we have extension requests for 23919S and 24019S.
Yes, Chairman, can you hear me?
We can.
Hello, Mr. Chairman and Commissioners. My name is Rudy Mendez, and I'm the owner and developer for the projects that were heard, and an extension was granted in June of 2019 for calendar 23919S and 24019S. Two structures, neighboring structures that involve one 6-unit, 3-story, 6-car garage structure, and another 3-unit, 3-story, 3-car garage structure. As I mentioned, there was an extension that was granted for residential use below the 2nd floor. It is a C12 zoned property. Due to the recent issues with the pandemic, and prior to that extension expiring on June 24th, things basically came to a halt. And because of that, and the subsequent financial and general contracting challenges I had, I am requesting an extension of that initial request for the special use.
And just to clarify, this is your first extension, I believe. What you referred to as your extension was just your original approval for the special use.
My mistake, thanks for clarifying. Yes, I received that initial approval on June 24, 2019. So this is my first extension of that approval.
Got it. Can you just give us an update on where you are with your delays, and do you anticipate being finished in the next year?
I do anticipate starting construction, hopefully within a few months. As I said, I had a delay. Things came kind of to a grinding halt. I think now they're starting to come back. But it put me in a position where I had to make some changes in terms of my general contractors and my project manager. Unfortunately, I lost someone working with me who's close to coronavirus, and then I had a family member I lost. There was just much happening, and but I believe I can get this back on track in the next few months.
Okay. Any questions from the board? Thank you. We'll take it under consideration.
Thank you both. Appreciate it.
Mr. Chairman, this is Victor again. We also have one more request for continuance. On page 6, 19720S. They're working with the department. They have some landscape and parking issues that they're trying to address. Nick Fatikas is the attorney, and I can promote him in.
Yes, please do. This is 19720S.
Correct.
Okay. Yeah, let's get the counselor on record too.
Might have lost him here.
Nope, I'm back.
Oh, you're there? Okay.
Okay, thank you, Chairman Nick Fatikas from the Law Offices of Sam Banks. I'm here on behalf of the applicant Rebuild Foundation, a not-for-profit corporation in Illinois, 19720S. We were able to get the parking determination letter from the department. This has been continued once for that purpose. We're now making adjustments to our landscape plan. We're hoping to have those adjustments no later than Monday. So we will be absolutely prepared for the 21st if there's availability on that agenda.
Okay, so 19720S, we're going to continue until August 21st. Again, no further notice on this one.
Thank you, sir.
Thank you, Counselor. Let's move next, slightly out of order, to 24021Z and 24121Z, 24120Z. This is at 1721 West 21st Street.
Good morning, Mr. Chairman. Tyler Manick on behalf of the applicant. I'm joined by, can you hear me?
Yeah, please proceed.
I'm joined by Matthew Plecky, the owner of this particular property, and Ron Elkins, the project architect. The applicant seeks variations to reduce the parking requirement by 2 parking spaces and to reduce the required rear yard open space. The
Counselor,
variations
before you proceed, let me just swear on your witnesses so I don't forget.
Yes.
Later. Mr. Plecky, do you swear to tell the truth in these proceedings?
Yeah, this is Matt. Yes, I do.
And Mr. Elkins, you swear to tell the truth in these proceedings?
I do. Yes.
Okay, go ahead, Counselor.
Thank you, Mr. Chairman. Once again, for the record, Tyler Manick, the attorney for the applicant. The variations are required in order to adaptively redevelop an existing 3-story legal 5-dwelling unit building, including the addition of 2 ground floor units for a total of 7 units. The variations are required because there is insufficient area of the lot to add 2 parking spaces for the 2 additional dwelling units that are permitted as of right under the Chicago zoning ordinance. The property, although not allowed under the current zoning district, is considered a transit served location because it is less than 500 feet from the CTA bus line number 9 off of Ashland. And it is also 1,500 feet from the CTA 18th Street Pink Line station. Thus, parking is unnecessary at the site, whereas in contrast, the applicant will be unable to achieve a reasonable return on the cost necessarily incurred to bring the existing dilapidated building up to current building code standard, if the parking requirements are strictly enforced. Further, the lot has existing non-conforming rear yard open space.
Counselor, I think we lost you.
Hello?
Oh, you're back.
Going to.
And we lost you again. Mr. Plecky, are you still here?
Yes, I am.
You are the project architect?
I am the owner of and developer of the building. Ron is the architect.
Got it. Let's see if Counselor.
I believe so. Should I go to my witnesses?
Yeah, why don't we? And then if you drop off again, we can have them flesh out the rest of your application. Your case.
Mr. Plecky, can you state your full name and address for the record?
Sure. My name's Matt Plecky. I live at 2100 Westbury in Chicago, Illinois.
And what is your relationship to this property?
I'm the owner and developer.
And did you sign an affidavit that was submitted with your findings of fact?
Yes.
And were the statements you made in the findings of fact true and correct?
Yes.
And do you adopt as your testimony here today the testimony you provided in those affidavits?
I do.
Unless this board has any questions for Mr. Plecky, I'll move to Mr. Elkins.
Let's keep going.
Mr. Elkins, can you state your full name and address for the record?
Sure, Ron Elkins. My business address is 1137 West Webster in Chicago.
And what's your relationship association with this property?
I and my firm were the project architects for the redevelopment.
And are you a project architect licensed with the state of Illinois?
Yes, licensed in Illinois, 4 other states, 25 years experience. So yeah, this is a typical project for our firm.
And did you prepare the plans that were submitted with the findings of fact?
I did, yes.
And did you sign an affidavit that was submitted with the findings of fact?
I did, yes.
And was the testimony that you provided in the affidavit true and correct?
It was.
And do you adopt as your testimony here today the statements and testimony you provided in that affidavit?
I do, correct.
Mr. Chairman, at this time, we'd be happy to answer any questions.
So just to summarize on the first request for the rear yard open space reduction, the argument is that you already are providing the square footage requirement, the 252 square foot of open space, but it's not in a 10 by 10 configuration. And because the department has started to interpret the code that's required, your hardship is you're already non-compliant and you'd have to tear things down to get that configuration, correct?
Correct.
And then on your parking request, the hardship is that because you're attempting to add a new unit, you'd have to add an additional parking space, and you're already taking up the entire width of the lot. Is the hardship?
Correct. Correct.
Okay, any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you, Mr. Chairman.
Thank you.
Okay, we're gonna go back to regular order of business. We are on 22720S. This is at 1652 East 53rd Street.
Chairman, I don't see anyone from for this case.
Ingrid Cheatham, we don't have.
No, I don't have anyone signed it. Let me contact her.
Okay, we'll keep going. Let's do 22820Z and 22920Z. This is 2855 North Ashland Avenue.
Justin, did you have a question?
I'm here, Corinne O'Hara.
Okay.
Good morning.
Good morning.
Let's see. Are you pro se on this one, or do you have a representative?
Well, I'm an attorney, and so I'm representing the company. And so I'm the owner, attorney, and representative of the company.
Okay. Why don't you go ahead?
Okay. You know what? You faded out. What was that?
Why don't you go ahead and present your case?
Okay. Hi. For the record, I am Corinne O'Hara. I'm the attorney and the one of the owners of Correct Builders Corp. We are seeking a variance due to the fact that we would like to install a 3-foot by 3-foot catwalk between the existing exit stairs and the garage roof deck. Pursuant to plans, this is actually a brand new 2-unit building, a duplex up and a duplex down. The exit stairs are fireproof already. Now the exit stairs basically end about 3 feet away from the garage. So the rear yard has already been built. Everything's already been built. It's established. However, there's this little kink in the code that permits this catwalk for single-family residences, but it does not permit it for multifamily residences. Because of that, we need to apply for this variation in order to install the 3 by 3 foot catwalk. A staircase would not be in the best interest of this property. It would take up the already teeny tiny yard that is there. As you can see from some of the pictures, there is a paver patio that is also brand new. If we had to install a staircase, that would take up the entire yard. Secondly, the existing staircase is just completely perfect because it ends 3 feet before the garage deck, and then it provides easy access to the new owners who would own this. This does not change the neighborhood. It does not affect any congestion. It doesn't affect anything. But it actually, in my opinion, it is a safety concern because if we as the builder had to install a staircase versus using the catwalk, people would just be catapulting their stuff over the staircase. They'd be jumping over the railing and to protect them and just ignore basically the safety issues because they don't want to go down and then up again. And this is an incredible improvement for the future residents, and it is actually in completely consistent with the neighborhood because there are so many catwalks all over the place in the Lakeview neighborhood. I've spoken to one of the neighbors. He just wanted to make sure that nothing was changing in terms of the height of the deck or nothing is changing. It's just for that little 3 foot by 3 foot. And I have my architect here, structural engineer, excuse me, who I could swear in, and I would like to adopt his testimony in the affidavit as well as adopt my testimony that is within the affidavit.
Why don't you go ahead and do that, and then we'll get into questions.
Okay. Are you Michael Cox?
Let me actually just give him the oath.
Oh.
Mr. Cox, can you see us or hear us?
Yes,
Going to tell the truth in these proceedings?
I do.
Okay, go ahead, Counselor.
Good morning, Michael. Are you Michael Cox?
I am.
And you work at 120 West Madison, Chicago, Cook County, Illinois?
I do.
And you're a licensed structural engineer?
Yes.
And you have been a structural engineer for how many years?
Yeah, about 17 years.
Okay. And have you testified before this board on many occasions before?
I have.
Okay. And have you been considered an expert with respect to your testimony?
Yes.
Okay. Now, turning your attention to the affidavit that was submitted to the board. Do you recall executing this affidavit?
I do.
And is this affidavit true and correct?
It is.
And if we were to adopt this affidavit as your testimony, would your testimony be substantially the same as the affidavit?
It would.
Okay, no further questions. Move to adopt it.
Okay, so Counselor, you said this building is 2 years old?
No, I said it's a 2-unit building. It's a brand new building.
Brand new. And so
Right.
you built it?
Yes. Corrette LLC purchased this building in purchased the land in 2007. It had an existing 2-flat on it. The new construction just completed a few months ago, and that was under permit number, trying to remember the permit number, sorry. Well, it provided for a brand new 2-unit building, a duplex up and a duplex down. And that's the building that you see right there. And those are the exit stairs.
Right.
So we already have the fire code exit stairs that come right off of the building.
So my question is, how is it that you have not created your own hardship? I mean, you knew about that code requirement. You built the building this way. Talk me through that criteria for the variation.
Well, I don't really see, because that we created the hardship because this is how the stairs had to be. And if we had to install a staircase, it's really not feasible because these are the plans that had been previously approved. Since everything that is existing there with respect to the stairs, with respect to the deck, since that's all previously been approved, the city has already approved what is actually there. So I don't see that by following what the city has previously approved under the brand new construction, how that is creating, how I'm creating that hardship. It's a hardship for residents if this variation is not approved. So with respect to the staircase, this is how it had to be. The exit stairs had to be this way, and it just promotes the consistency of the building, the safety of the residents to allow this catwalk. And it is already consistent with the neighborhood, so I don't see how we created the hardship.
Go ahead.
This is Commissioner Garcia. Could you explain why they had to be this way?
Are you asking why the stairs had to be this way?
Yeah, you said they had to be this way for the exit stairs, so can you explain why? Like, why couldn't they have been closer to the building, or like what required
Oh,
this to be this way?
understood. Oh, first of all, this is on Ashland Avenue, and as you may or may not know, Ashland Avenue, when the busier streets came in, you know, they reduced the length of the lots. It's only a 107-foot long lot. So you have to have a certain pitch of your stairs. You have to have a certain landing area for the stairs, for everything to be code. So for the exit stairs to be code, they had to be built this way. And that, by virtue of the fact of how that had to be built, creates the anomaly of it being actually very close to the garage and it eliminating most of the yard. So it's what the city approved in the plans for the original construction of the 2 units, and in combination with how the exit stairs had to be designed for fire safety, for safety in terms of the pitch, and so that they're not too steep. And then for enjoyment of the future residents of the small paver patio yard that is actually there. Does that answer your question?
Kind of. If you reduced, it looks like each unit has kind of a back deck on the back. If you reduce the size of that back deck and put the stairs in its place, would it still comply and meet those requirements?
No, I mean, that's because then you don't have the exit that is necessary. I mean, you've got to remember, if there is an issue with respect to fire or a danger, you know, CO danger, everybody has to be able to get out of their places and exit very quickly and very easily. The exits that are there right now, exit right from their back door, and they can go down and out without any scurrying around. It's, you know, these are homes that are designed for families with children, so everybody will be able to get everybody out there. Wide staircases, they're completely within code, and it ostensibly also it is the safest route for everybody with these stairs as they are. I mean, because the stairs are completely to code, and it would just be very you know, difficult and quite just not practical for stairs to be built any differently.
I have a question, just maybe you said this, but if you could clarify for me. I'm Zurich Esposito. Your permit drawings would have included, it looks like, a garage rooftop deck. What did those permit drawings, how did they indicate access to it would be achieved?
Actually, it was silent on that. On the original, it was silent. It approved the deck, but it actually didn't have it didn't have a staircase on it. If you look at the original plans, it was silent on that.
Okay, thank you.
Mm-hmm.
Any other questions from the board? Can I just ask,
Sure.
You bought the property as a vacant lot, or at any rate, you tore down the building, right?
Tore down a building, right. Tore down an existing 2-flat.
And at what stage in the process did you realize that this was going to be a problem?
At the very, very end.
And why was it that did not become apparent until the very end?
Lack of foresight.
Got it. Okay. Any other questions from the board?
Yeah, this is Jolene Saul. So I just want to confirm the like catwalk piece was not in the permitted plans.
Right.
You had the deck, you had the rear stairs, but you had no access to the deck in the permitted plans. Is that correct?
Yeah, that's, I mean, yeah, it was, basically it was an oversight, and that's, so that would be, yeah.
Did you market the units with a rooftop deck?
I'm sorry?
When you marketed the units, did you market them as having that access to the rooftop deck? Have you started marketing the units?
They, yeah, I believe so. I'm sure.
And did you ever amend the permits after you had built the building?
No, that's why I filed for the new permit. I mean, I'm saying that this was an oversight, and I'm trying to correct the oversight. I mean, really, I'm trying to do everything correctly because of the oversight, and what we're asking for doesn't change anything for anybody in the neighborhood. It's very consistent with the neighborhood, and it's just it's a 3 foot by 3 foot. And I almost think it's an anomaly in the code that the code doesn't permit it for multi-units, but it permits it for single families. And I mean, it would be an incredible hardship not to allow it because everything is there.
What can I ask you, what part of the code are you referring to that allows catwalks for single family? I mean, I know that there's the whole, it's referred to as the Hopkins Amendment, but that's where building and that's for adjacent stairs. So what
Mike, can you answer that? Because I got that info from you.
Yeah, I believe actually the code is not allowed for either multi-unit or single families, for catwalks specifically.
Oh, I thought it was.
Is your hardship argument is essentially that the code does not allow you to do what you want to do?
No, the hardship argument is that there will be no yard that exists at all. It will take up the entire staircase would take up the entire yard, and a staircase will be would provide actually a danger for other for residents, because the stairs will butt up the current stairs, and then people are just going to hop over a railing. People are just going to end up hopping over a railing and not ignoring the fact. So I mean, what if you have teens there and you have kids that are hopping on things versus just being able to walk directly across?
One of the other, if I could just interject really quick, one of the other hardships is the fact that if we were to do a stair, it would take up a significantly larger area than this small catwalk that we're calling would take up.
Yeah.
I have a couple. How big is the current yard that you all are referring to that if you did this by code, it would reduce that space?
It's smaller than 200 square feet. It's smaller than, it's about 8 by, the exact dimensions.
It's 9 foot.
9 foot. Okay, thanks, Mike.
And then are these condos, rentals?
No, they're going to be sold. They're for sale.
Have they sold already, or are they on?
They're being sold. Yes.
Meaning they're under contract already, or you're still marketing them?
No, they've sold.
They have sold.
Yes.
Okay. And so this catwalk's built already?
Yes.
The catwalk is built already.
It is, and yes, that's what I mean, it's built, and I didn't know that we didn't realize that there was a problem because there wasn't and that's when we realized there was a problem. And as soon as we did, that's when I started this process, literally immediately.
So that's what's on the left in that picture. So wait, so did you amend your permit or you got cited and then had to come in to amend it?
Neither. No, as soon as we were advised that this was an issue, I contacted our architect and had plans drawn immediately and started this process.
Who advised you that it was?
What do you mean?
How did you realize that the catwalk you had built was not permitted?
The inspector.
So you were cited?
No, he didn't cite it. He just didn't, no, he didn't clear the permit. It's not a site, it's not cited. I mean, to me, cited means that we're fined. We weren't fined. He just said, hey, you got to get this, you got to have a variance for this. And then I was told about it and started this process and came immediately. I mean, went very quickly.
So the original permits did not have a catwalk. You built everything, built the catwalk. When the inspector came in to give you whatever it is, your certificate of occupancy or whatever it is to approve after you had built it, he observed that you had built a catwalk and said, that's not permitted?
No, he didn't say. He said, hey, you need to get a variance for this. That's he said, hey, you need a variance for this. And so then I was contacted and I started the process immediately.
Yeah. So why was the catwalk not in the original permit permit plan that you had proposed, if you were going to build it all the while?
I don't know. I can say with respect to that, I don't know. It was basically an oversight because there weren't stairs in the permit and there wasn't anything. And so it was built. And as soon as we realized that we needed the variance for that, we started that immediately. I mean, that's why it was started, because I mean, because there are so many in the area, and it was an oversight. And
may I ask once again though, was the roof deck on the garage part of the permit drawings?
Yes, it was. Yes.
And who is the architect of this project?
Michael Cox.
I'm sorry, could you repeat the question? I'm sorry.
I thought Michael is an engineer.
I am. I also produced the drawings for this project, yes.
So there would be no access included in those drawings for permit that were approved?
The access was not included in the original permit drawings.
But the roof was actually drawn as an occupiable roof deck?
I'm sorry, I'm trying to gather the original permit drawings here to see what was actually shown. I don't have it right in front of me right now, but.
Okay.
While you're doing that, are the current homeowners aware of this issue?
Oh, yes, absolutely.
So if this variation's not approved, are they okay with that? Or is there some contingency or arrangement you have with them?
Whatever we have to do, we have told them that we will do it. It's 100% on us.
Who does your entity still have an interest? What is the interest your entity has in this property? You said that you've sold both units already.
Yes, our interest is in completing the access to the deck. That's what the access to the roof deck. That is what we are doing. We are and we have warranty issues and we contractually obligated ourselves to take care of any access issues that are related to the deck.
If I could just interject too, the original permit did not show roof deck on the drawings, just a flat garage roof.
Are you sure about that, Mike?
Yeah, we just looked it up. We do not call it a roof deck.
I thought,
Well, that would explain, of course, why there would be no need for a stair or access to it in order to get the permit.
hang on, let me.
Valenziano, I see you've joined us. Why don't you go ahead?
Yeah, hi, Steve Valenziano, Department of Planning and Development. The original permit was not approved with a garage roof deck. The plan examiners would not have approved it. They would have issued a denial and they would have come to the Zoning Board of Appeals. However, now they built it with a roof deck and with the stair access, the catwalk access. They originally had a stair in the backyard that was less than a foot away from the garage roof, but that way they could build everything out, they can get their permit, they could move forward without having to go to the zoning board. Now, though, they cannot get their C of O on their permit because the inspector went out to look at everything and sees that there is a garage roof deck and access to it from the stair that is in violation of the zoning ordinance. So that's where we're at today. They're trying to correct what they did so that they can get their C of O and sell the property.
So a variance is needed for more than just the catwalk, is that correct?
Well, I'm also.
The variation is needed.
Hold on,
The
one at a time.
variation is needed for the catwalk because the ordinance was amended several years ago to provide access to these rooftop decks. Alderman Hopkins and Alderman Smith introduced that. City Council passed it, and it provides for access from the ground on a stair that is parallel to the garage wall and that is no more than 4 feet wide. This is something that we've seen a lot of, and they kind of, for whatever reason, to get their permit more quickly rather than going to the zoning board, they just don't draw the stair deck or the catwalk going to the roof deck. And now they have to do that to get, like I said, to get their C of O on the property.
I'm looking at the original plans, the permitted plans, and it does provide for the roof deck because it has 5/4 treated wood decking with 2x tapered wedge sleepers. The roof deck is on there. The roof deck is on there already. That is, if you look at the garage wall section, it is right on there. We would not have built that if we did not believe that we were not permitted for the garage deck. That is, I can tell you that right now, because that is right on there. The roof deck.
So it appears from both the department and your architect that it was not. So, Mr.
Well,
Cox,
if you look at the plans, I just read it to you. It has the wood decking with 2x tapered wedge sleepers. I mean, so it already has the construction of the deck. You have to have the sleepers underneath it, and then you have to have the treated decking above.
Right, was this submitted for permit?
And this is what was submitted. And this is what was passed for permit. This is right on page AR 1.4 of the original plans.
what's the date on those plans?
Hang on. I gotta look. I gotta pull something else up to find out the date.
And while she's doing that, Mr. Cox, I would like you to figure out what the date is on the version that you're looking at.
Chairman, this is Steve Valenziano again. I'm looking at the plans for the approved garage, and on the front elevation of the garage, that little cutout that you see on the photograph that was shown, there is no cutout. There is no access to any roof deck. I can tell you, I've seen hundreds, if not thousands of these, and there was no roof deck.
Yeah,
it says right on the plans. It says on the approved plans, flat roof, build floor to resist a 100-pound live load. That's all it says. It does not call out a roof deck. There's no access to the roof deck. I'm looking at the plans right now.
If you look, okay, I
I'm
agree,
looking at
but
the
look at
plans
the
right
garage
now.
wall section. If you look at the garage wall section, you look at the garage wall section, and that's where it has a 5/4 treated wood decking with 2x tapered sleepers. I mean, that's where we're getting it off of. I mean, honestly, there was never any intent not to do this and not to do this correctly. And this is the plans of June 18th, 2019. I mean, because it's right on there. I mean, and that's the, and that's exactly what I'm looking at. If you look at the garage wall section,
Chairman,
it's exactly where it's.
Chairman, I'm looking at the garage wall section and it does show that. However, the garage roof plan on the same sheet does not reflect that, does not talk about it. Look at the elevations that, again, the elevation page sheet, there's no access to that roof at all. So, I don't know why you would have built a roof deck with no access to it.
In all sincerity, I mean, in looking at this, we really believed that this was approved. So, I mean, if we had not thought that the deck was approved, I would have been in here a heck of a lot earlier. I did not know that at all. We did not know that. I mean, because if you look at where it says, the 5/4 treated wood decking, I mean, that we truly believed that was approved. The carpenter thought it was approved. John Downs is a very experienced general contractor. He's the carpenter. Did everything, ordered fire. I mean, we ordered fire resistant decking, did everything, just did everything that we could to do this correctly. And, and I apologize. I mean, I apologize for not doing it correctly. I did not intend to do it incorrectly. I really did not. I mean, because that's why I said, I said repeatedly in my affidavit, and I stand by my affidavit in terms of being truthful, that with the naming of the decking and putting in the sleepers and everything you had to put in underneath so that you don't have leaking, we really thought it was approved. So, and in terms of building, there are certain things that are done on the fly, like placement of a door or things like that. And with this being right on the plans, there was every intention of following these plans correctly. And if I had actually understood that this part had not been permitted before, I would have approached this very differently. Because I really anticipated that everything was approved, because it has that there. It talks about the live load in terms of the foundation that was poured. I mean, it's an actual foundation. If you look at the wall section and the foundation that was poured for this, it wasn't just a little garage slab like you normally do. It's for the 3000 PSF load bearing. So you look at the wall section in combination with all of that, and that's where we were getting that this was approved. And then if you look at the fact that with the fill that had to be done, everything, we believed that this deck was approved. And in terms of the final inspection, they approved the deck. When we went through the final inspection, he just said, "Hey, you got to get the catwalk approved." We're like, "Oh, really?" And so that's what happened.
Okay. Thank you, Councilor. I want to just, for Mr. Valenziano, I neglected to swear you in. So do you swear to tell the truth in these proceedings and that what you've said previously is the truth?
Yes, I do.
And did you have something you wanted to add?
The only thing, again, I would just add is that on the approved plans, there is a 3 foot, 5.5 inch gap or space between the stairs and the garage. On the approved plans, the elevation of the garage that faces the house, there's a parapet, continuous parapet along that garage wall. There's a continuous parapet on all four sides of that garage. So I know my examiners, this is a zoning issue, and my examiners would not have approved this. It would not have approved a roof deck with a catwalk. They would have sent to the zoning board of appeals. They would have issued a denial. So if this was done to avoid that, well, that's why we're here today.
Any other questions on the board?
Yes, could you talk a little bit about if the variance isn't approved, what would happen? Like what would need to happen to make these structures compliant?
Commissioner, say that one more time. You were breaking up on my end.
I'm sorry about that. If the permit was, or if the variances are not approved, could you talk, Mr. Valenciano, a little bit about what the resulting structure would need to look like?
If this variation is not approved, then they will need to go back to what was approved, the approved permit drawings that would have a 3.5 foot space, nearly 3 foot 5.5 inch space between the stair tower and the garage. And they would have to put the parapet wall back to a full continuous parapet wall on that, I believe it's the south elevation. I don't know which way I'm facing now. Oh no, I'm sorry. That would be the west elevation. But the front elevation is what it's labeled as.
Mm-hmm. On that, that would be that would make it compliant with the rear setback requirements and the backyard requirements?
Yes, I mean, everything else was approved. I believe they're only in for the variation on the catwalk.
Okay, so it would just be the removal of the catwalk and the reconstruction of the wall.
Right.
Make
Yes.
it not a roof deck. I just wanted to make sure I was understanding what the variances were and how they aligned with what was before us. Thank you.
Any other questions from the board? Counselor, you're on mute. Hold on one second. Any other questions from the board? Okay, Counselor, final comments.
Well, I have a question for, a few questions for Mr. Valencia. Is the, if you look at the wall section on the plans, isn't it true that that is the footing and the slab that was approved? Isn't that really for a load-bearing garage and not just a standard garage slab?
That's what it looks like, but there's no, yeah, sure. That's what it looks like. No, that's true, but there's nothing in the zoning ordinance that says that you can't provide an extra strength foundation or footing to your garage. There's nothing that says that you couldn't put but it does say that you can't connect it to the garage, and that's what was shown in the plans. That's what my examiner stamped off on, was a garage that was separated, detached, not connected in any way, and no way to get on top of it.
One at a time, Counselor, you got to stop interrupting.
But I'm asking, can I ask one more question, please?
Counselor, we're doing one at a time, okay? We have a court reporter who cannot do two people at the same time. Go ahead.
Isn't it, Mr. Valencia, doesn't it already have in the garage wall section, doesn't it show that there is wood decking with sleepers that was already approved?
I've already answered that, yes.
Okay.
Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
We're going to jump up back to 22720S. This is for 1652 East 53rd Street. Cheatham, is it?
Yes.
Hi, go ahead.
Hi, good morning, Chairman and members of the board. Do I have permission to read my opening statement to you guys?
Sure.
Okay. Chairman and members of the board, thank you for hearing my appeal. My name is Ingrid Cheatham and I'm a licensed.
Sorry, I need to swear you in. Do you swear to tell the truth in these proceedings?
Yes.
Okay, go ahead.
Okay. I'm a licensed cosmetologist here in Chicago. I have operated salons for 6 years and have worked within the beauty industry since I was a child. To build my business in Hyde Park has been a dream of mine since moving to Chicago. A huge dream that I've worked on. So today I'm seeking your support and approval to operate my salon that will provide customers with eyelash extensions, skin and nail beauty enhancements. In my initial application, I erroneously included all the things that I hope my business will grow into. With the assistance of business affairs and consumer protection staff, I've learned that my aspirations will require multiple steps. To be clear, I have every intention of returning before you to request additional special use permits for laser hair removal and microblading. However, for this application, I am simply seeking a license to begin operating my salon. I pray that you will not hold my ambitious initial application against me. And in my work to ensure that the business will meet the standards of the city of Chicago, as well as the local Hyde Park community, I've garnered support from 5th Ward Alderman Leslie Harrison and Hyde Park Chamber of Commerce. Both letters of support are included for your review. That I am prepared to answer any questions that you may have, best of my ability.
Can you clarify for me? I thought from somewhere it seemed like you were moving an existing business.
So our old location was 2240 South Michigan. And then upon signing a lease and getting this location, I didn't know that I had to actually, I thought I could just change the old business license that I had to this address.
Got it. And so how long were you operating the prior business?
I've had that location for 3 years.
Got it. And how many employees are you anticipating at least starting with at the new location?
4.
Got it. Okay. And then your hours of operation are 11 a.m. to 7 p.m. Tuesday through Saturday?
Yes.
Got it. Okay. Any questions from the board? And can you clarify, so you're here for the special use to establish your salon, and then you're attempting to do microblading, and you mentioned one other use as an accessory use, I assume?
So I'm here today to establish a salon for skincare and lash extensions, and I plan to follow up with you guys for a special use for laser hair removal and microblading later.
Got it. Okay. Any other questions from the board? Okay, thank you. We'll take it under consideration.
All right, thanks. Have a good one.
Mr.
Chairman, I have to read the.
I'm sorry. Ms. Velasquez, if you'd read the department's recommendation.
Yes. Good morning. My name is Jeanette Velasquez, and I'm here to read the recommendation from the Department of Planning and Development.
Velasquez, do you swear to tell the truth in these proceedings?
Yes, I do.
Go ahead.
The department recommends approval of the proposed beauty salon. The department finds that this proposal complies with all the applicable standards of the zoning ordinance, is in the interest of the public convenience, and will not have a significant adverse impact on the general welfare of the neighborhood. The department also finds the proposed beauty salon will be compatible with the character of the surrounding area, and it is also designed to promote pedestrian safety and comfort.
Okay, thank you. We'll take it under consideration.
Thank you.
We're going to move to let's do 23020S next. For 1606 North Harding. And Ms. O'Connor, when you're ready, I'll swear you in and then you can start. Can you hear us?
I can hear you.
Perfect, we can hear you. Do you swear to tell the truth in this proceeding?
Yes.
Okay, why don't you tell us what you're trying to accomplish here?
I'm seeking a special use to establish a nail salon that's located within 1,000 feet of existing personal service. Located in B1/2 2 neighborhood shopping district.
And can you tell us a little bit about your experience in this industry?
Well, I am a licensed nail tech. I've been a licensed nail tech for 6 years now. This is actually my second, place of business. I used to have a salon in Bronzeville, and I had that for about 3 of those years. And now I'm just seeking to come back into the community that I was born and raised in to bring business to that area and build it up.
And are you still involved in the prior business, or you're out of that one?
No, I'm out of that. I wanted to move over here initially, but I just couldn't find a location at the time.
Got it. And can you tell us about how many employees you're anticipating at the beginning?
Right now, it's going to be 2 of us because it's like a boutique nail salon. So it's appointments only, and it's only 2 nail techs right now.
Got it.
And I believe that it's going to stay that way, actually, because that's the type of business that I was anticipating from the beginning to run. So.
Got it. And your hours are 8 a.m. to 9 p.m. Sunday through Saturday?
Yes. Yes.
Okay. Ms. Velasquez, if you read the department's recommendation, and you are still under oath.
Once again, my name is Jeanette Velasquez. For this proposal, the department recommends approval for the proposed nail salon. The department finds that this proposal complies with all the applicable standards of the zoning ordinance, is in the interest of the public convenience, and will not have a significant adverse impact on the general welfare of the neighborhood. The department also finds the proposed nail salon will be compatible with the character of the surrounding area in terms of design and operating characteristics. And lastly, the nail salon is designed to promote pedestrian safety and comfort.
Any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
We are going to jump ahead while we have Mr. Valenziano from the department here. We're going to go to 24420Z, bottom of page 4. This is for 1733 North Hoyne Avenue. And Mr. Matchak, when you are ready, I will swear you in.
Oh.
Morning. Can you identify yourself for me?
Sorry, it took us just a moment to get audio caught up. Could you say that again?
Can you identify yourself for me?
Absolutely. My name is Samantha Booth, and I'm here with Jordan Mayshock. We have our architect joining us as well, so I want to make sure that she's on the line.
What's your architect's name?
Catherine Darnstadt of Leighton Design. It says that she's raising her hand in the Zoom.
Okay. While she's getting set up, do you swear to tell the truth in this proceeding?
I do. I do as well.
And there's our architect. Can you identify yourself for me?
Catherine Darnstead with Leighton Design.
And do you swear to tell the truth in this proceeding?
Yes.
Okay. Then why don't you guys go ahead and present your application?
All right. Well, as I mentioned before, my name is Samantha Booth. I'm co-owner of the property. I'm here today with Jordan Mayshock, who's also a co-owner of the property. He's going to be serving as our primary property owner witness. I will also be testifying as necessary, but serving primarily in the attorney role for these proceedings. And then Catherine, of course, is our architect, and she'll be serving as our expert witness as well. So we've already been sworn in. So just to give a brief overview of our project, we're seeking a variation in connection with the permit to permit us to replace an existing 22 by 20 foot A-frame and vinyl garage with a 21 foot by 23.5 foot cinder block and thin brick clad garage with a custom rooftop deck. We are requesting a variation to the city's zoning ordinance rear setback requirement to permit us to build the new garage with a 1 foot setback Multiple of our neighbors on our block have a similar rear setback to the one that we're requesting, including our immediately southern neighbor. Strict compliance with the zoning ordinance would create a practical hardship for the subject property for multiple reasons, chiefly because the lot in question is a non-standard size and shape. It is only 100.5 feet long and thus shorter than the standard Chicago lot. There's also a 2.27 by 23 foot encroachment onto our property from the southern neighbor on the southwest property line. And that is immediately adjacent to the footprint of the new garage and the existing garage. And finally, our southern neighbor's lot is non-conforming in many respects, including that he has built his lot all the way to the southern lot line. His home is connected to his garage. His garage has a non-conforming setback that's actually equivalent, the equivalent 1 foot setback to what we are requesting, as you can see in this picture. And his house is very tall, so it blocks a significant amount of light to our property. So with that overview, Jordan, can you please state your name and address for the record?
Jordan Mesha, 1733 North Hoyne Avenue in Chicago.
Okay, and what's your relationship to the variance application under consideration today?
I'm the owner of the property and the applicant.
Okay, great. Did you execute an affidavit in support of that variance application?
I did.
Is Exhibit A to the proposed findings of fact a true and correct version of that declaration?
It is with a single caveat
Oh, yeah.
in paragraph 10, wherein I state that a letter indicating support for my neighbor is attached. That letter came after the deadline for me to submit it, so it is not attached to this.
Great. So besides that clarification that you just made, does your declaration reflect your complete and truthful testimony?
Yes, it does.
Okay. Do you adopt the testimony given in that affidavit today?
Yes, I do.
Okay. I have also submitted a declaration in support of our variation request. Again, my name is Samantha Booth. I'm stating for the record that I'm the owner of the property located at 1733 North Hoyne Avenue. Exhibit A is a true and correct. I submitted an application in connection with the variation request. Exhibit A, the affidavit of Samantha Booth, is a true and correct copy of that affidavit. It does reflect the testimony I would give if called upon to testify today, and I adopt it formally with respect to today's proceedings. So then, Catherine, would you please state your name and address for the record? Or I guess you don't need to state your address, your name and credentials for the record, please.
Sure, Catherine Darnstead, licensed architect and self-certified architect in Chicago. And our office address for Layton Design is 900 North Ashland. We've been working on this project with the homeowners for some time now, and it is a replacement of the existing garage that is there.
Great. Have you testified in these hearings before?
Yes, I have.
Okay.
Not related to this case.
Right, correct. But you have experience, okay. And what did, let's see, let's go to that. Did you submit an affidavit in support of our variation request?
Yes, we did submit an affidavit in support of the request.
And does Exhibit B reflect the true and correct version of that affidavit?
Yes, that is correct.
Does Exhibit B reflect your truthful and complete testimony that you would give if called upon to testify today?
Yes, it does.
Great. Do you adopt Exhibit B? Do you adopt that testimony in Exhibit B?
Yes, I do.
Thank you. So I think I had a couple of follow-up questions for Jordan. Just a little bit of testimony that postdates the affidavit, so he wanted to just supplement if that's all right with the board.
Sure, go ahead.
Did you, Jordan, did you also submit a document identified as Exhibit D to the city? So this is Dominique's.
Yes.
Okay. Is Exhibit D a true and correct copy of your contractor's quote for the base cost of the construction for the garage, excluding the rooftop deck?
Correct.
Okay. Okay. Beyond what is reflected in your, turning back to your affidavit, Exhibit A, beyond what's reflected in that affidavit, have you discussed the requested variation with any of your neighbors?
I have discussed it with both our northern neighbor and our southern neighbor. Both have informed me that they support the variance, one of which was able to write me a letter, though post-dating the deadline to submit it.
Can you identify the names of the neighbors with whom you've spoken?
Jeff and Corinne on our north side and Joe Levy on our southern side.
And approximately when did you speak with Jeff?
I speak with him weekly as his backyard garage deck is a much higher elevation than mine, so I see him every time I'm in my backyard.
And on what basis do you believe that he supports the variation application?
He has happily told me so many times and has watched and consulted on our construction every day.
All right. With that, I just ask the board, what questions they have for us.
Can you clarify for me? You said your neighbor who has the cutout has a rooftop deck already?
Yes, he does. It is not over his garage, it is over his roof.
Got it. And are there other, I'm just looking at the aerial shot of this and it doesn't look like anybody else, as far as I can tell on the block, has a rooftop deck. Is he the only one?
No, there's a couple.
There are two garage top decks
yeah.
to our north.
I think not the immediately adjacent house, but the next one.
The following two.
Yeah, the following two both have decks. And like I said, our southern neighbor has a roof deck, just not a garage deck. But he has a lot of non-conforming use on his property. You can see it's built over the entire southern property.
And do you know, presumably I don't know, presumably, but I'm trying to make sure I separate and understand the hardship argument. There's sort of one, this tract that the lot is short. And then two is this, what I'm understanding to be an argument that without the variation, you cannot have a rooftop deck that gets light. And that's sort of, there's an argument there that that's a hardship and has some, I'm assuming, marketability impact. So can you clarify for me, is everybody on that line has the same presumably depth of lot or similar lot depth that's substandard?
Correct. Everyone on our street has the same lot depth.
However, our lot is different than every other lot. So you are correct. There are multiple distinct reasons, each of which we think independently would show hardship, but we've presented them all for your consideration. But in addition to the lot depth, you can see from this picture, we have an encroachment onto our lot right where the garage, right directly adjacent to the garage. Yeah, so that very much limits the width, the maximum width that our garage could be. So when you take that encroachment plus the 3-foot sort of alleyway you have to keep to have an egress to the rear of the property, plus the stairs to go to the rooftop deck, you're left with limited interior space in the garage. And we are investing a very significant amount of money, as the documents that we've submitted demonstrate. And that doesn't even include the additional money being invested on the roof deck to improve this property, to bring it into alignment with the neighborhood, and quite frankly, into alignment with all our neighbors. We're the only, old dilapidated vinyl home on the street. And so, yes, the interior space, maximizing the interior space in order to make sure we can fit 2 cars is very important for the marketability of the project. And then the second argument, yes, is that our southern neighbor blocks a very significant amount of light to our property. And so having a variation rear setback that aligns with his would help us to have access to sunlight on the rooftop deck.
So to be clear, the variance is for both the garage and the roof deck. So without the variance, they wouldn't even be able to construct the garage as is.
Got it. Mr. Valenziano, I see you have something to add, and I'll just remind you that you're still under oath.
Yes, Steve Valenziano, Department of Planning and Development. The reason that they're here for the variation is not for the rooftop deck. In this case, they are building the access and the rooftop deck in compliance with the zoning ordinance as was amended by Alderman Smith and previously. The reason that you can only have 60% of your rear yard open, your required rear yard setback can be used for garage. The garage can only occupy up to 60% of your required rear yard. This one is, which in this case would be 466 square feet. This garage is 520 square feet. Therefore, to build anything larger than that 466 square feet, you need to reduce your required rear setback. So that's what they're here. That's what that's for. Then also the code requires you to have a 2-foot setback off of the alley. In this case, there's only setting back 1 foot. So that's the reason. It doesn't have to do with the rooftop deck. Doesn't have to do with access to the rooftop deck. In this case, they're doing it as the code prescribes. It's just that the garage is slightly larger than what it could be. And if it was, and if that southern or that lot to the south of them did not intrude on their property, they could build a 500 square foot garage. So it's just kind of, that's their hardship, I believe, is that the rear setback is not the full length of the lot, or the full width of the lot, I'm sorry.
Got it. Any questions from the board? Okay, Counselor, anything you want to add?
Just if we'd like an opportunity to respond to any concerns you have, if there's any elements that you're not sure about.
Seems like we have no other questions from the board. Okay, thank you. We'll take it under consideration.
Thank you.
Very quickly, Chairman, will the person who has their hand raised that has identified themselves as 475574, can you identify yourself? You have to turn your mic on. I need 475574 to identify themselves in the case that they're here for. But you have to turn your mic on. All right, Chairman, we can keep going. They're not identifying themselves. We can proceed.
Okay, we're going to move to 23120Z and 23220Z. This is for 4955 South Washington Park Court.
Who are you? Hello. So I'm Kiefer Dunn. I'm the architect, and I'm here with Mark Holt, the owner and applicant.
Great. Do you both swear to tell the truth in this proceeding?
I do.
I do too.
Okay, why don't you proceed?
Okay, my name is, thank you, Chairman and members of the board. I'm the owner of 4955 South Washington Park Court. And I'm going to hand this over to my architect, Kiefer Dunn.
Hi. So this is an existing single-family residence in an RM5 zone. 4955 South Washington Park Court is also part of the Washington Park Court Historic District. It's a very interesting street. The lots are smaller than a typical Chicago lot. This lot in particular is 19 foot 6 inches wide and 97 feet long. And the house itself is relatively bulky and leaves us only 23 feet and some inches by 19 foot 6 in the rear yard to work with. So what the client is trying to accomplish is this. So there's an existing wood frame garage in the rear of the property. It leaves some room for egress from the house and a small egress gangway, but there's no rear yard open space to speak of. So we have two variation requests. One is to allow us to build a new garage with a roof deck so that there's both parking and a rear yard open space. And to do that, we need to be allowed to have rear yard open space located 6 feet above grade. That's one request. The other deals with setbacks. So we, because we only have 23 feet 2 inches to work with, And we need to make space for an egress stair from the back of the house, and obviously leave room for a car. We have to, and we can't be 2 foot, we can't be set back 2 foot from the alley. We have to be a little bit closer in. So we're requesting a 1 foot rear setback. The existing building already runs from lot line to lot line because it's a very narrow lot. And so the garage would also, the garage does not go all the way to the lot line, but we are requesting some relief on the side setbacks as well. So that's the situation.
Any questions from the board? Okay, thank you. We will take it under consideration.
Thanks.
Thank you.
We're going to take a 10-minute recess break, so we will reconvene at 11:07 a.m. Commissioner Toya seconds. Commissioner Garcia?
Yes.
Commissioner Saul?
Yes.
Commissioner Esposito?
Yes.
Commissioner Toya?
Yes.
I also move yes, so we will be in 11:07.
For the person signed in with the phone number that ends in 2573, can you identify yourself?
Victor, it's Julie Valak. Hello?
Yes?
Victor, it's Julie Valak,
Victor for
WLAC.
Summerdale, right?
14, case 144145, 1443 Summerdale.
Okay, give me 1 second. Let me rename you here.
I have a question, Victor.
Sure, go ahead.
You asked the person who identifies as 475574 to identify themselves?
Yes.
That's the password to this.
Yeah, I know. Somebody signed in with
Yes.
that.
Oh, all right. No, I signed in on my phone and it ends in 2573.
Okay, sounds good. Thank you.
Can you tell me when they'll bring that case up?
We're going in the order that's on the agenda, so I couldn't give you a time.
Could you look on the agenda for me and tell me approximately where it is?
It'll actually be the last case.
Okay, and how many cases between 231, which was just finished, and the last case?
2, 3, 6, 7, 8, 9, 10. There's 10. There's 10 ahead of you.
10 cases ahead of us. Okay.
Yeah. Okay.
One more question, Victor. If I disconnect, I'm by phone, not on computer. So if I disconnect, can I sign on again? Because I got to call my plumber.
Yes. Yes.
So
Just make sure when you sign in, you just name yourself with your name.
I can't because it doesn't ask me for that. It asks me for the
Okay.
password.
What are the last 4 digits?
The
of your
last
phone
4
number?
digits, 2573.
Okay. When I see you again, I
It's
can rename you.
registered. I'm primarily listening in anyway, but I do want to hear the case at the end.
Okay, that's fine.
All right.
Yeah, if you have to
Thank
sign
you,
out,
Vic.
as long as I know your last 4 digits, I can rename you. That's fine.
All right. Thank you, Victor. I'll
You're
try
welcome.
to, if it's only 10 more cases, I can get him later this afternoon. It's not an emergency, but thank you.
Okay. Okay, you're welcome.
Mhm.
Will the person who signed in as 50401 identify yourself? You have to unmute your mic. You have to turn your microphone on so we could hear you. I don't know what case you're here for, and I can't promote you unless I know what you're here for, so you have to turn your microphone on. The person who signed in is John. Can you identify yourself and what case you're here for? You have to turn your mic on, John. Adam Kingsley, can you unmute your mic for me?
Yep.
Do you have Lisa? I couldn't
No,
read-
she's not going to testify. She should have submitted a letter. You should have that letter in the record. She's not going to be live.
Okay, yeah, because I couldn't read her email on your sign. So it's just you and your client, correct?
Correct.
And that's Tracy. Okay, thank you.
Got it. Thanks.
Nick Fatikas, do you have all of your clients with you for how? Patrick Green,
Yes.
they're with you physically?
No, they're not with me physically. They're signed in under Jennifer Breen. I had sent an email to you earlier.
Okay, gotcha.
Got it?
Yep, thank you.
No problem.
You had a question, Louis? You have to mute your microphone.
I just want to make sure, I know we're on page 5, but I want to make sure you can hear me.
Yep, I can hear you. You're
All
good.
right, thank you.
Thank you. Joanna, will you be speaking on how?
Mr. Haris Pervez, you have joined using 2 Zoom instances. Please log out from one and just use one instance. Thank you. Again, that was for Mr. Haris Pervez.
Okay, I move that we reconvene this meeting of the Zoning Board of Appeals. Commissioner Saul seconds. Commissioner Garcia,
Yes.
Commissioner Saul,
Yes.
Commissioner Esposito.
Yes.
Is Commissioner Toya here? We are missing Commissioner Toya. Looks like we still have quorum, so we are reconvened.
Excuse me, Chairman, before we start, I have someone who identified themselves as Georgie Porgy. Can you?
Yeah.
What
That's
case are you here for?
my name is Kevin Erker. Sorry, that's my daughter's iPad.
What case are you here for?
1443 West Summerdale.
Okay, thank you.
Chairman, I'm here, just so you know, Sam Toya. Thanks.
Toya is here. We have our full set of commissioners. So we're going to start on 23320S for 322 North Latrobe. While we are getting set up, I'm going to read the department's recommendation. The Department of Planning and Development recommends approval of the proposed transitional residence for up to 17 women, provided the special use is issued solely to the applicant Road to Righteousness DBA Emma's House, and the development is consistent with the design and layout of the plans and drawings dated July 7th, 2020, prepared by Luis A. Martinez, architect.
Good morning, Commissioner. My name is Samantha Bates, and I am the applicant and owner for Road to Righteousness Foundation, doing business as Emma's House. And we're seeking the request for a special use permit to operate a women's recovery home.
And before we proceed further, do you swear to tell the truth in this proceeding?
Yes, I do.
And Mr. Musauer, do you swear to tell the truth in this proceeding?
Yes, I do.
We recognize your expertise. Okay, applicant, why don't you go ahead and present what you're attempting to do here?
Our mission is to revitalize and assist with sober living, to help restore one's sense of pride and dignity to live within the community. And Emma House wants to raise awareness and curb the epidemic of substance use disorder. Emma House sits in a prime location where it is an epidemic and infested with drug addiction and overdose. Our house is looking to make a difference in the community. I am a recovery coach, and I want to help remove personal and environmental obstacles in recovery and link the newly recovered person to the recovery community and serve as a personal guide and mentor in the management of personal and family recovery. I have a letter of support from the Alderman, which is Alderman Metz, and Congressman Danny Davis, and I have several linkage agreements with other community organizations that's a part of this epidemic and pandemic that has infested our community, which is Haymarket, Gateway, Loretta Hospital, Bobby Wright Mental Health Center, Above and Beyond, CRCC, Reaching to Restore Family Services, Herbert Ballard Foundation, Chance After Chance Ministries, and GEO Reentry Services. And so today we're looking to get a special use permit to open up our facility to house 17 women.
Can you talk a little bit about your experience in this field?
Well, my experience is I am a recovery coach. I've been in this field for the last few years. I am a long-time recovering addict. So I'm well aware of what's going on in our community. And I know this issue is one of the issues that needs to be addressed because we have people that are dying in our community from opiate abuse and addiction. And I would like to be a part of making a difference and bringing awareness to people in my community with the help of the people in the community. And one of the things that's going on is most women that are addicted to drugs and our substance abuse users do not have a place to go. And we want to be a part of setting the goal and the pace for them to have somewhere that's stable, so they can get the support, so they can go back into their families and become productive adults.
In your prior few years of experience, this is your first facility that you've actually run?
This is my first facility that I have run, but I have been a part of social service all my life. That's my passion. I had a daycare that I ran for 20 years. I had a summer camp for the youth. I had a summer feeding program for the youth, and I ran a food pantry in my community. So social service is my passion.
Got it. Can you talk a little bit about the other staff? It's up to 17 women actually in the facility or in the house. How many other members of your team do you have that are helping you manage?
We're going to have 4 people that's going to help us manage, 2 during the day and 2 during the night. This facility is going to be 24 hours. We have volunteers that's going to come in and help us maintain stability in this house. It's a big house, but I have people that's on board with me that is willing to help me do the job that we need to do to make sure the women stay on track.
And how are you getting people to come into the house? Are you getting referrals from some particular place, or is it just entirely people call you up and come on by, or how does that work?
I am getting referrals from Haymarket, Gateway, Above and Beyond, CRCC. And what we do is a telephone interview over the phone. And then we, once the telephone interview is done and we decide that if that person is right for the house, we let them come in and we let them tour the house and let them know our rules and regulations as far as what we expect them to be doing. And our principal goal is working on the 12 steps and teaching them accountability, discipline, responsibility, and most importantly is honesty and integrity.
And can you talk about the flip side of that? How do you discharge people, if that's the right word?
Well, we make sure that they're ready to go back in society. We make sure that they're making their meetings, they're doing the things that they need to do to become productive adults back into the community. We make sure they're making their meetings. We're making sure they're going to their self-help groups. We have a weekly schedule that they fill out, and it's more so independently, want to make sure that they are sincere in what they're doing and that they're taking all the necessary steps to stay clean, to stay sober. And so we have created a recovery plan and guidelines of what they must follow. One is going to self-help meetings. The other is making talking to their sponsor on a regular basis. So not only am I as a staff member or the people that's involved in the house a part of this recovery, but also them making meetings and going and talking to their sponsors on a regular basis.
And can you talk a little bit about what are you anticipating the average length of stay would be?
Anywhere from 6 months to a year. It really depends on the person that's coming into the house that's sincere about their recovery.
Got it. And then a couple other questions on my end. Do you have any restrictions on visits?
Yes, we have restrictions on visits. For the first 90 days, they will not be allowed visitors, and they're supervised visits. Whereas we know who coming into the house, they're signing in and out of the house. No one is to come into the house without prior approval. So it has to be prior approval. It's in a common area, so it's not going to be in any of the bedrooms. We have a basement where we hold our community meetings at, so visits will be conducted in the community area where we hold our meetings at.
Got it. Can you talk a little bit about any disciplinary rules that you have if people aren't following whatever the rules are? Is there ever a circumstance in which you would remove somebody from the property, and how does that process work? Particularly if it's, say, overnight hours, or you're just putting people on the street? How do you manage those situations?
No, I wouldn't just put anyone on the street. I believe in second chances. I believe in giving a person an opportunity to get our rules and regulations down pat, because most people that's coming in, they're not used to being disciplined. They're not used to being said, this is the way we want things done. And so I believe in giving people an opportunity to get stuff right the second chance. But if it ever comes a occurrence where we can't seem to get people on track and for them to follow the guidelines and rules, we will discharge them, but we will not discharge them with putting them out back on the streets where they have nowhere to go. We will refer them to other organizations that are willing to take them. We won't just put them out there and say, guess what, you're on your own. We're going to take them to the place, we're going to call and get a referral, and we're going to refer those people to those places that they need to be to get the help they need.
Okay. Last question on my end is, are there just, this is an unusual question because we haven't seen one of these shelters in the current pandemic, but presumably there are a whole set of rules that you have to be aware of and monitor, and to the extent you have people kind of coming in and out of this this house. Are you up to speed on what those are, or at least aware you have to get?
Yes, I am. I am up to speed with those things. And that's one of the reasons why we have not accepted anyone, because we know that we're going through this this pandemic with this corona. So we have 6 foot distancing. We have masks, we have gloves, we have sanitizers. We make sure people, when they do come in, they change their clothes that they coming in the street off of, and they're washing their clothes. We have a facility on the premises where they can wash their clothes. We're making sure they're washing their hands. We have signs that are up. We have social distance literature that we have printed up from the city's website that we have placed, in the areas for social distancing.
Got it. Mr. Musawir, you submitted a report as the expert for this application. If you were to testify on this, I'm assuming it would be consistent with, your comments would be consistent with your report that you submitted?
Yes, sir. Good morning, Mr. Chairman and members of the board. Kareem Musawir at 221 North LaSalle Street in Chicago. Yes, that is correct. I would testify that in accordance with the affidavit that was submitted. And obviously this is a use that is most important when our situation of the pandemic and other health issues are, and financial issues are facing families. Homelessness is becoming a health hazard, and it has to be as many of these types of facilities established in order to address those issues.
Thank you. Any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you so much.
Thank you.
Okay.
Next up is 23520Z at 3329 West Washington Boulevard. And for our applicants, when you are ready, if you go ahead and identify yourself for me, we'll get everybody squared in. Mr. Kingsley, are you the counselor for this project?
Yes, yes, I am.
Okay, why don't you identify your witnesses and I'll swear them in, and then you can present your case.
Okay, Tracy Locke is with us. She's the owner of the property. Tracy?
Hi, this is Tracy Locke.
All right, do you swear to tell the truth in this proceeding?
I do.
Great.
So Tracy purchased this property. It is a historic orange rated property. I believe in one of the things you have in the file is a letter from Lisa DiChiara at Landmarks, Illinois, explaining the historic nature. It's Tracy's desire to rehab the property. Most of the rehabilitation is interior and doesn't need a permit. The one thing that we do need a permit for is a new back staircase, open porch, essentially. To do that, we need a side yard or variance from the side yard setback because there essentially is no side yard setback on the west side of the property. The good news from our perspective is that Tracy owns the vacant lot on the west side of the property where the side yard setback would be. So Tracy, why don't you explain a little bit about your vision for the project?
Being a small business owner, not too far from the property, I have worked in that area probably for the last 12 years, and I thought it would be obvious a great opportunity for me and my family to live close by where we work and we serve in the community. So my plans is to make that our primary residence, which is totally to renovate, but keep the structure, the footprint, the original footprint of the house as is. I have the support from my neighbors, from the 28 Alderman Jason Irvin as well. And for the most part, I think this is going to just kind of bring that area to life. I mean, the plans for the most part has been approved by the city, all but the various, and it's definitely going to do something really awesome for the community.
And so the argument on the hardship is that your existing side setback is non-compliant. So essentially you can't really add the new porch and preserve the landmark property without the variation. Is that correct?
That's correct.
And so I just want to confirm that the porch you're adding is following that the existing non-conforming line from the house, right?
Correct. It's not increasing the non-conformance. It personally couldn't because it's right on the property line. But yes, it's following the house.
Got it. And then what is the plan for that adjacent vacant lot?
Tracy?
I'm sorry. So eventually my plans is to build a 2-story property next door, which I have my son who's in college and a couple nephews, and we're planning on to build that. And my son is actually going to occupy one of those units. So our plans is to do something great with both of those lots, not to make it as it is right now as an eyesore to the community with all the drug activity and so on and so forth. Although there's a church next to the adjacent vacant lot, that area just is a high crime for drug activity. And what we want to do in our vision is just to clean that area up. Being and raised in the city of Chicago, we have a vision just to do something awesome in that area.
Got it. Any questions from the board? Okay, thank you. We'll take it under consideration.
All right, thank you so much.
Let me ask you before you go, Counselor, did you already go to landmarks permit review process?
It's not, it doesn't need a landmarks. It's not an actual landmark property. So we don't need to go through, it's an orange rated property. So it's at historic value, but we don't need to go through the landmark process, the landmark permit process.
Okay. Okay. Thank you. We'll take it under consideration.
Thank you.
Thanks. Next up is 23820Z at 1057 to 59 West Taylor. Counselor, when you're ready, if you'll identify your witnesses, I'll swear them in and then you can proceed.
Thank you, Mr. Chairman. My name is Mark Kupiec. I'm the attorney for the applicant. And I have with me on the call, hopefully, I have my associate Agnes Pleka. I have also Harris Pervez on behalf of the applicant, and also John Hanna of Hanna Architects.
Okay, Mr. Pervez, are you there?
Yes, I am.
You swear to tell the truth in this proceedings?
Yes, I do.
Mr. Hanna, are you there?
He's joining in just now, Chairman.
Okay. Why don't you go ahead, Counselor, and when he gets here, we'll swear him in when it's his turn to speak.
That's fine. So, Mr. Chairman, the relief we're asking for is a variation of the rear setback. We'd like to reduce it from 30 feet to 10 feet. One of our unique circumstances is the fact that this is a short substandard lot, only 95 feet deep versus the standard 125. So we're only 76% of a standard depth. This is proposed a mixed-use building on Taylor Street. We do propose retail on the ground floor to be compatible with other buildings on the street. This is a corner property at the end of the block. We do have a 20-foot public alley at the rear of the property, and there is a high school athletic field across that alley. For this specific project, we were before the city council for a zoning change. Before that zoning change, we did appear before the ward zoning advisory committee. The athletic field I mentioned is used by St. Ignatius High School, and we have been in touch with the school. At their request, we sent them a copy of our plans, and they did send us an email that they have no objection to this project. So with that, I'll call my witnesses. Did you want to swear? Is Hannah on yet, Mr. Hannah?
I think he dropped out.
I continue with Harris then, hoping he's coming back.
Sure, let's proceed that way.
Good. My first witness then would be Harris Pervez. Harris, are you on?
Yes, I am.
Harris, would you please state your name and your address?
Horace Pervez, 7000 North Kilpatrick, Lincoln, Illinois.
Harris, is it true you are a member manager of the applicant LLC?
Yes, that's correct.
Also true that your LLC owns the subject property?
Yes.
Harris, you heard my introduction. The facts I say in the introduction sound accurate to you?
They are accurate.
Good. Also true that you had signed an affidavit for this case, which we filed on your behalf?
Yes, I did.
And if I continue to question you, is it true that your answers would be consistent with that affidavit?
Yes, that's correct.
So, Mr. Chairman, unless you had questions of Harris, we would stand on his affidavit.
Why don't we see if there's any questions so far from the board? No? Okay. Do we have Mr. Hannah or somebody from his office here yet?
Hopefully. Mr. Hannah, are you on?
No, we don't have him.
Mr. Chairman, this is Agnes Pleca, one of the other attorneys. He just called me and he told me that he's having some technical difficulties. So he's trying to log out and log in again to see if that would clear up.
Okay. We'll just proceed on this one. There's no questions for the architect from the board, looks like.
I was just going to ask to reiterate the hardship on this one.
Well, the hardship is primarily hardship is the unique circumstances that it is a short substandard lot. It's only 95 feet deep in a business zoning district, and this is a business zoning district. It's a blanket 30-foot rear setback, whatever the depth of the lot is. So if we had a standard lot at 125, much easier to address that 30-foot rear setback. We're only 95 feet deep, which is only 75%, still subject to that same 30-foot rear setback. So it's very difficult to get a decent sized building if we had to observe that full 30-foot rear setback on this short lot. We'd build a much shorter building, which would not give the applicant a reasonable rate of return. Especially in a case like this, where with the zoning change, at the request of the alderman in the community, we limit our height to 4 stories. And because we're on Taylor Street, we do retail on the ground floor to be consistent with the other retail on the street. So we only have 3 floors to work with to fit our residential units. So if we observe a full 30-foot rear setback, the building is so short, you can't get units large enough to make a reasonable rate of return.
Any other questions from the board?
Any comments? This is Zurich Esposito. Anything to be said about community feedback?
Well, sure. Again, we appeared prior to the zoning change, we appeared before the ward advisory committee, which I forget, 12, 15 people, whatever we had, and they had some specific questions about it. We obviously, the plan provide retail on the first floor, which they asked for because this is Taylor Street, which is an arterial street. So we provided that retail, not for our benefit, but to be compatible with the other stores on the street. The old building, the existing building was an old building on one lot, and actually the second lot was used for outdoor vehicle storage. So that was an issue at the meeting, and right after that meeting, the applicant removed those vehicles that had been stored there for some time. Bought the property. I think those are the main questions that were asked at that particular meeting. And of course, because this is a corner property, those rear units have plenty of light and air, so the 10-foot setback is adequate. The alley's 20 feet instead of the normal 16 feet, so it's a wide alley. And across the alley is an athletic field, so there's plenty of light and air for the rear of the building. St. Ignatius got a copy of our notice. At their request, we sent them the plans, answered whatever questions they had, and they sent an email back that they have no objection to the project. Arguably, they might be affected because they're directly across the alley. So we had no complaints in connection with any of the notices sent out, either the zoning change or the zoning board case.
Looks like we have Mr. Han online. Mr. Han,
Yeah, I'm here.
do you swear to tell the truth in
Hello.
this meeting?
I do.
Okay, go ahead, Counselor.
John, state your name and your address.
John Hanna, President of Hanna Architects Inc., 180 West Washington, Chicago, Illinois.
And you're a licensed Illinois architect,
I am.
and you're the architect for this project.
I am.
And John, is it true that you signed an affidavit for this case, which we filed on your behalf?
That's correct.
And if I were to continue to question you, is it true your answers would be consistent with that affidavit?
They would.
Mr. Chairman, we'd stand on John's affidavit unless there were questions.
Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thank you very much.
Thank you.
Next up is 24220Z at 3763 North Sheffield. Counselor, when you're ready, if you'll introduce your witnesses, I'll swear them in. Counselor, you there?
There, now am I here?
Yeah, we can hear you.
Thank you. And do I have my architect, Mr. Hornoff, and Mr. Schroeder?
Looks like you've got Mr. Lerner here.
Mr. Lerner, okay. And Brian Schroeder, no?
Not yet, unless they're together.
No, we're not.
I don't have a Brian Shorter that signed in.
We have a William Hornoff who's joined us, I believe.
Yeah, Hornoff is the architect, and Lerner is one of the owners, but the affidavit was signed by Schroeder, who is also an owner. So they were both going to be on.
I have someone calling in. Tom, let me see if this is him.
Thank you.
Whoever, your phone number ends 5928. Can you identify yourself, please?
Oh, hello. I'm not for this case. My name's Kevin Erker for 1443 West Summerdale.
Okay, gotcha. Thank you.
And this is Bill Rodenhornoff, the architect on the project.
Okay, so we're missing Schroeder. So, Counselor, why don't we?
Excuse me, I think that Mike Lerner is going to join us instead of Brian.
No,
you need him as well.
We need Schroeder because he signed the affidavit.
All right, we're going to come back to this one then. Counselor, I think you've got 243 up, so why don't we do that one as well, and we'll see if we can get Mr. Schroeder in the interim.
Okay, so on this one, hopefully I have Jake, the manager for the LLC, and Mr. George Fajero. Do I have those two gentlemen?
Yes, Jake is here, Jake Eldreddy, LLC
Great.
property manager.
Mr. Chairman, did you want to swear them in?
I do, yeah. So, Mr. Aldretti, do you swear to tell the truth in this proceeding?
I do.
And then is it Mr. Fajardo? Jorge Fajardo, is it? Can you, are you there?
Yeah,
Perfect. Do you swear to tell the truth in this proceeding?
I do.
And then is there Andrew Clement? who's-
Thank you. So, Jake, this is a,
Before you proceed, is there a Andrew Clement that you need for your case?
I'm sorry, what?
Is there an Andrew Clement that you need for this case? We have another. person.
Andrew was having trouble signing in. Is he in? Is he here?
He should be dialed in by phone, but he doesn't have a camera.
Okay. So is Andrew here by phone?
No,
I just spoke to him a few minutes ago. He said he could hear everything, but he doesn't have a camera. So he could see us and hear us, but we can't see him or hear him. Does that make sense?
Well, but can he speak?
Look, I have two numbers here, Tom. Let me see if this is one of these
Yeah.
is him.
I think one of them, his would be 773-718-1067.
No, if you're signing with a number 50401, can you identify yourself? Yeah, I don't think we have him, Tom.
And he's the actual manager of the LLC, right?
No, the actual.
That's me.
Well, yes, that's right. We have the property manager who does the day-to-day, but Andrew is the actual owner who isn't as familiar. That's why we were going to have Andrew talk to the nitty-gritty details, but have Andrew on just so he could, because, he's the owner.
This is tech support. My recommendation, if you can reach him, if he can disconnect and then connect back in.
Okay, I think so because he's the manager and the representative of the LLC. I do want him on. So why don't we counselor for both of these?
Jake Eldreddy, I'm the manager, so I am here.
You're the manager of the property,
Yeah,
right? You're not the
correct.
manager of the LLC, which is the applicant.
I am
Right.
the LLC property manager.
Yeah, you're the
Yeah,
property
I
manager.
represent
Are
LLC.
you a member of the LLC or the designated manager of the LLC entity?
Yes, that is me.
Entity itself.
Andrew, correct. He is in Wisconsin and he is not present. He did tie in earlier, but was having technical difficulties.
Okay.
And I signed the affidavit, so I'm the person.
But so I want to just clarify. You're the manager of the property. Who is the manager of the LLC?
That's me, the LLC. Yes, correct. I'm sorry, I was confused.
And
Okay.
Who is that? Here, it looks like we actually have Andrew joining anyway. Okay, so Counselor, why don't you, let me actually just swear everybody in. I don't know if
Okay.
Point. So I swear in Jake, I swear in Jorge. So Mr. Clement, can you hear us? Mr. Clement, you there? Mr. Clement, are you there? Okay, Counselor, why don't you go ahead and start, and we'll see if he can figure out his mute issue.
Thank you very much. Sorry for the confusion. Jake, we described this property. It's a commercial property, always has been in the downtown area. Has a taco restaurant on the ground floor and has traditionally had 2 commercial uses above. Is that right?
That is correct.
And now the plan is to make an apartment on the 3rd floor. Is that correct?
That is correct.
And the problem is it's a 100-plus-year-old building that goes lot line to lot line. And it has a 10-foot alley behind it in order to add a apartment on the third floor, which would otherwise be as of right, we're supposed to add a parking space as well. Is that right?
Yes, correct.
But the business takes the entire ground floor, and B, even if there was room to put a garage or a parking space into the building in the back, the 10-foot alley really wouldn't allow it, wouldn't allow turning radius to get into it. Is that right?
That's correct. Currently, the 10-foot alley, you couldn't even pass through with a vehicle.
So it's virtually really impossible to add a parking space to this building as it exists and has existed for some 100+ years.
That's correct. And then Andrew has confirmed he can hear, but he cannot speak.
And
Hello?
There we go.
Yes.
Okay.
Hello?
Mr.
Wait.
Cummings, try to tell the truth in this proceeding?
Yes.
Great. And you
Okay,
are,
and Andrew, you are the actual owner of the LLC, is that right?
Yes.
And you have Jake doing the day-to-day management, and that's why we had him sign the affidavit, is that right?
Yes.
But you would like to, as the owner, you would like to create this third floor apartment, and Jake has described the problems with it and why we're here for the variation, is that right?
Yes.
Okay. So Jake, you and I worked out an affidavit directed at each of the criteria necessary for the board to grant this variation. And if you were to continue to testify, you'd testify consistently with it. Is that right?
That is correct.
And then Mr. Ficaro, are you on the phone as well? Jose? George? Do I have George?
I am. Can you hear me?
Yes, thank you very much.
Okay.
You have designed the apartment that would go on the third floor, and you've complied with all of the codes and ordinances of the city of Chicago, is that right?
Correct.
And you and I went through all the criteria necessary for the board. The only problem here is that we can't add a parking space because there's no place to put it. Is that right?
Correct.
And you and I went through each of the criteria necessary for the board to grant the variance. And if you were to continue to testify, you'd testify consistently with your affidavit. Is that right?
Correct.
Mr. Chairman, I think that's what we have, and we're available for questions.
any questions from the board? Okay, thank you. We'll take it under consideration. Let's try 242 again and see if we've found Mr. Schroeder.
I still don't have anybody signed in for that, Chair.
Okay, Mr. Chairman, could we pass that? Could you please move on to your other cases, and I will get on the phone and see if there's any way I can find him?
Yeah, and if you can let Mr. Risa know when you're ready, we'll try and slot you
Yes,
back
sir.
up before the end.
Thank you very much.
Okay, so next up, we are going to go to 245 20Z at 5201 South Oak Park. Mr. Weinstock, are you the attorney for this matter?
Yes.
If you will identify your witnesses, and we'll make sure we've got everybody here, and I'll swear them all in, and then you can present the case.
Yes, Your Honor. Thank you. Can you hear me?
We can. It sounds like you've got some background noise. But we can.
Thank you. My name is Louis Weinstock. I'm the attorney for the owner, who is also here remotely, Keith Gutillo.
Also, the architect, Sam Martirina, is also present, and they can all be sworn if you desire.
Great. So, Mr. Gutilla, do you swear to tell the truth in this proceeding?
Yes, I do.
And Mr. Martirina, do you swear to tell the truth in this proceeding?
I do.
Great. Counselor, please proceed.
Yes, thank you. This is seeking a variance on it's a single-family home at the given address. And if Mr. Martirina and Mr. Gutilla were called to testify, they both would testify in accordance with the affidavits, which I believe the board has in front of them. This is a single-family home which has been occupied by the owner, Mr. Gutilla, for the past 6 years, and they are seeking for a variance for the purpose of some setbacks to be able to add a second floor, which does have a rear overhang to go beyond the existing setback amount, which is the reason for the variance sought. The building would remain occupied by the owner and a single-family home. It meets all the other requirements consistent of the existing homes in the area. Many of the homes apparently in the neighborhood have been being added second floors, and this will also provide the aesthetic upgrades to the neighborhood, and that was the reason for the sought variance, because of the second floor and the overhang. And if there's any other questions by the board, be glad to address them through the witnesses.
Yeah, can you actually just elaborate, and you can do this through witness testimony, on what the hardship is?
Mr. Martirina, the architect?
I believe the hardship would be that they wouldn't be able to expand the house to be useful for themselves and their family at the current size that it is now, to put in all the current amenities and stuff like that. So without expanding the house, they would probably have to sell the house and find another house in another location.
And that's for the current size of the house, not the lot. The lot looks like it's a little bit larger than standard size, right?
Yeah, it's smaller. It's a smaller lot than in a typical RS2 lot. So it's an RS2 zoning. Yeah, it would be more of a typical lot in like an RS3 or a RT4. But for an RS2, it's kind of substandard size.
And so the argument is that without the addition, their properties market value, how does it compare to the rest of the block?
I believe a lot of the houses on the block have done a similar addition. I don't have the exact amount, but quite a few of them in their block have done the same type of addition.
Mr. Gutilla, can you speak to that?
Shut your mute off.
Mr. Gutilla?
Yes,
I can. In terms of other properties in the immediate area, have others done similar to what's being proposed here?
Yes, currently there's 2 on my block right now, and within a mile area, there's probably 8 or 10.
And how old is the home, to your knowledge?
It was built in 1954.
And so part of the reason for this, of course, is, as Mr. Martirina just said, you want to stay in the area, you want to stay in the home.
Yes, we like the area.
Any other questions, Your Honor?
I want to just stay on this for a little bit. So
Sure.
in the code at any rate, the sort of standard is less than 125, right, in depth, and this one I think is 133. So is the hardship argument that the house itself is small? I mean, how does it relate to the others on the block?
Mr. Martirina?
The house is smaller. Basically, we wanted to stay with the existing house line. Otherwise, if we had to follow the current code, we'd have to set the side yards in quite a bit, and on the addition also. So we were trying to stay with the current boundaries of the of the exterior walls with the side addition, with the sides.
So the argument is that the other houses on the block are larger. And so because you're sticking, as far as the addition to the existing house lines, and it's smaller than the other houses in the block, that's your argument on the hardship. But I'm following, right?
Correct.
Okay. Okay. Any questions from the board? And is the existing house, it's non-conforming in any respect or no?
I believe, yeah, it wouldn't be, if you built it brand new, I don't think, the side yards would have to be different. You'd have to, so it wouldn't conform to, so if you wrecked the house and rebuilt it, the side yards would be smaller, no.
Okay. So the fact that you're keeping on the lines with the existing non-conformity is your hardship.
Correct.
Mr. Valenziano, I'm going to turn to you and remind you that you're still under oath.
Yes, Steve Valenziano, Department of Planning and Development. The existing home is non-conforming as to its side yard, and they're just trying to follow the same side yard along 52nd Street. So that's the issue, is that it would be a very odd offset addition if they were to build it. But the building is non-conforming today based on that side setback, and that's what they're asking to match.
Got it. Okay. Thank you. Any questions from the board? Okay. Counselor, anything else you wanted to add?
Nothing at this time, Your Honor. Thank you.
Okay. We will take it under consideration. Thank you.
Thank you very much.
Next.
Thank you.
Thank you. We're going to go to 15920S,
I'm gone.
5945 West Madison Street.
Chairman, we don't have anyone for 159 and also for the next one, 162.
Okay. Do we know if for Mr. Moore for 242, if we've identified yet if we found Mr. Schroeder? Still no Schroeder. Okay. Let's get into 192 and 19320Z. This is 1909 North Howe. And I believe we have objectors on this one. Correct, Counselor?
I just unmuted. Can you hear me, sir?
Yeah.
So initially, yes, we had objectors, and we've since resolved the objection. If I can jump right into it, Chairman, we initially proposed an enclosed storage room behind the home, and that was met with opposition from both the local community organization and the Alderman's office. We've since removed that element or feature, and we're now only asking for the same zoning relief, but to permit the proposed stacked staircase along the lot's north property line. Based on our concession to take the enclosed storage room out and replace that with grade level permeable space, both the Lincoln Central Association and Alderman Smith have issued letters of support for the proposed variations. And I think Joanna from Alderman Smith's office was on the line and can testify independently of that, but to confirm the same. The technical issue before I turn the floor over is we needed to basically mark up our site plan and floor plan to show the footprints of the features stay identical, but the notes or the description by the architect change from underground storage to unexcavated permeable space. And those details were changed and sent over to both the Alderman, Lincoln Central Association, and Victor yesterday. But I know obviously with the constraints of the Zoom meeting, I'm not sure how you want to handle incorporating those into the hearing today.
Can you talk me through a little bit? this is the one with the staircase, right?
Yeah, so separate and apart from the storage component, we are proposing a stacked stair it basically goes from the basement up to the first floor of the home. And then that stair would be the same staircase used to access the rear, garage roof deck at the rear of the property. The program for that, again, maintains a terrace between the home and the garage. And the issue that had come up during the community process was the impermeability below that terrace. So again, we've taken out the storage component. Underneath the terrace will now be grade level permeable material, most likely stone, like crushed stone or gravel, something along those lines. But again, we still are asking for setback reductions and the relocation of open space to permit our stacked stair design. And part of the hardship in the case is that we do actually have about a foot projection from our neighbor to the north. Their two-story spiral staircase. So the design that's being proposed accomplishes two things. One, it preserves the most amount of open space that can be used by the family between the home and the detached garage. And it also effectively helps screen the two-story spiral stair encroachment. So there's a two-part gain in that respect.
Got it. Okay. Since it looks like we don't have any objectors, that's fine. You've already sent that revision to the department, it sounds like, and you said also to the Alderman's office?
And to the representative from Lincoln Central Association and more, the president.
Got it. Okay. Then why don't you identify your witnesses? We'll swear them in, and then you can proceed with the rest of it.
Okay, I have two witnesses. On behalf of the homeowner, Mr. Patrick Breen, PJ Breen. He is the managing member of SHC Dev LLC. And then I also have our project architect, Mr. Phil Casagrande. I'd point out that although the property is owned by an LLC, the home will be occupied by the managing member, who's it's a family of 7, so husband, wife, and 5 kids. So it is intended as an owner-occupied project. This is not a for-sale development. We did provide an economic analysis explaining that we're investing in the property for the home. We're not intending to turn a profit. And the features are, again, aimed at, or the zoning relief and the stacked stair feature is aimed at preserving open space between the home and the garage, and then screening that spiral stair encroachment on the north side of the lot.
Got it. Okay, so Mr. Breen, are you there?
Yes, I'm here.
And do you swear to tell the truth in this proceeding?
I do.
And Mr. Casagrande, you appear to be there. Do you swear to tell the truth in this proceeding?
I do.
Okay, great. Counselor, why don't you go ahead then and flesh out the rest of your case and get your witnesses on.
Perfect. Patrick, can you please state your name and address for the record?
Patrick Breen, and current address is 1510 North Mohawk Street, Chicago, Illinois.
And you're the manager of the applicant, SHC Dev LLC, is that right?
Correct.
And that entity owns the subject property at 1909 North Howell, right?
Yes, it does.
You heard my explanation and agree that we've made changes at the request of the community organization in the Alderman's office to address their concerns with the enclosed storage room behind the property or behind the home?
Yes, we have.
That feature from your plan, is that right?
Yes, we're removing it.
We are moving forward on the program for the stacked stair along the north side of the property, right?
Yes, hopefully.
Patrick, you submitted a findings or a witness statement on, I'm sorry, my office prepared and you signed a witness statement in this case, is that right?
Yes.
You were to continue to testify, would that testimony be consistent with these statements in that witness statement?
Yes, it would.
Counselor, I think you maybe moved away from your mic. You suddenly got very quiet.
I'm sorry, can you hear me better? Okay. Phil, can you state, actually, it looks like you're on mute. Phil, can you unmute? And can you state your name and address for the record?
Yes, hi, my name is Philip Casagrande. I'm an architect in Chicago, and my office is at 3920 North Ashland Avenue.
And you have testified before the Zoning Board of Appeals as a professional architect.
I have.
You designed the program for the reorientation of the backyard at the subject property. Is that right?
Yes, I did.
And again, we've agreed to remove the enclosed storage area.
Yes, Mr. Breen agreed to that. Mhm.
Are pursuing the stacked staircase along the north side of the property to both preserve open space between the home and the garage and screen the 1 foot encroachment caused by that spiral staircase. Is that right?
That's correct.
Otherwise, the footprint of the home and the footprint of the proposed garage all remain without change. Is that right?
That's correct.
And Phil, it's your understanding that my office prepared a witness statement on your behalf in this case?
Yes,
And if you were to continue to testify, your testimony would be consistent with the statements we provided. Is that true?
yes, it would.
Chairman, that concludes our case in chief. If you have any questions or you or the board members have any questions, we'd be happy to answer them now.
I do want to just make sure I'm following the change to the plans across the 3 variations. So in terms of the reduction of the rear setback, you still need that. That's part of how you're actually connecting the stairs to getting access to the roof, right?
Because it's a perpendicular stair, yes.
Right. I thought that the reduction in the south side setback was because the storage you were putting under the terrace made it encroaching. And it sounds like you're not doing the storage, but you still need that variation.
My understanding we do for the footprint of the, I'm sorry, on the north side or the south side? I'm sorry, I want to be clear.
South sides.
Okay, so on the south side, there is no longer an encroachment because the footprint of the enclosure no longer counts as an encroachment.
Right.
But the combined side setback reduction is still required in my understanding because we're reducing the rear setback to accommodate the staircase. So they impact one another. Does that make sense?
Yeah.
Phil, do you agree?
Yes, I agree. They're going to want to push that setback to the back of the garage, actually. And that will require the 2 side setbacks to be
And
reduced.
Mr. Valenziano, since we have you here, will you just confirm that that's your view of it as well?
The only question I had was, is the backyard above grade?
It's less than 4. It's at 3 feet 11 inches, so it doesn't count as a technical encroachment.
Okay, then I would,
terrace
yes, I
space.
would agree. Yes.
Okay. And then for the 3rd variation, the relocation of the rear yard open space, you obviously still need.
We
nothing
do
there.
because we're by reducing the rear setback, the technical rear setback, we now have to account for the open space above the garage. Yes.
Okay. And at the end of the day, the hardship argument, you had, I guess, 2. One was that it was just essentially a waste to not be able to use that storage space that you have under the terrace. And then the other argument, it sounds like, is really about screening off the neighbor's encroaching circular staircase.
Which is a specific hardship on our property because again, we're dealt with a 1 foot encroachment that not many of the other neighboring properties have to deal with. Although I would also point out in our findings of fact, we submitted an exhibit or a photo exhibit showing approximately 21 properties that have similar rear setback encroachments of some kind, whether it's a staircase, whether it's a raised patio. In some cases, there are coach houses. So there are certainly other similar, different, but similar encroachments in the rear setback, making the proposed consistent and compatible with the makeup of the properties around us.
And then I think you also had noted that you've got a lot of the other properties in the area also have the rooftop garage deck. I think there was an argument.
They do, especially on our exact block, yes. And that's noted in the exhibit that was submitted.
Any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
Thank you.
Thanks very much.
Okay, let's Mr. Reese, is it safe to assume no progress on Mr. Schroeder for 242 and on 159 and 162?
162, I just spoke to the applicant He's trying to sign in. 159, no reply, and nothing from Mr. Shorter yet.
Okay, let's go to 19420Z. This is at 1301 South California. Counselor, when you're ready, I think we have Mr. Ravetna here.
Okay, perfect. Thank you again, Chairman. For the record, Nick Fatikas from the Law Offices of Sam Banks. We're here this afternoon on behalf of Lania Build LLC. The applicant owns the subject property at 1301 South California. The subject lot measures 50 feet wide by 132 feet deep, and it's improved with a 3-story, 13-unit apartment building. The applicant is proposing to finish the currently unfinished basement space and add 3 units within the building. Although the RM5 zoning allows the unit count, the unusual building footprint limits the number of off-street parking spaces that can be added to meet the new requirement. Today, there are no parking spaces provided, and unfortunately, only 1 new parking space can be incorporated, again, based on that footprint of the existing building. So in order to permit the additional units, the applicant is seeking a variation to reduce the technical off-street parking requirement from 3 parking spaces to 1. Mr. Ravetna in this case is both the managing member of the applicant. He's also a licensed architect that has previously testified on other matters. He'll be our only witness in this matter, and I defer to you to swear him in now.
Do you swear to tell the truth in these proceedings, Mr. Ravetna?
I do.
Okay, great. Go ahead, Counselor.
Cyrus, can you please state your name and address for the record?
Cyrus Ravetna, 340 East Randolph Street in Chicago, Illinois, 60601.
You are the managing member of Lania Build LLC,
I am.
and that entity owns the subject property at 1301 South California, right?
It does.
You're also a licensed architect in the state of Illinois?
I am.
Testified in that capacity again on other matters before this board. Is that right?
I have.
With respect to the subject property, again, it measures 50 feet wide by 132 feet deep,
That's correct.
and it's improved with a 3-story, 13-unit apartment building. Is that right?
That's right.
And your plan is to finish out currently unfinished space in the basement and add 3 units within the footprint of the building.
That's correct.
The issue is that and the particular hardship in this case is that the footprint of the building is quite atypical, and it limits the number of off-street parking spaces that can be added to support those new units, right?
That's correct.
So although the new technical requirement is 3 parking spaces, the best we could do is fit or incorporate 1 new parking space on site.
That's right.
Otherwise, the unit count, the floor area total, the setbacks, all the other zoning bulk requirements are met with this proposal. Is that right?
That's correct. Everything is
Cyrus?
within the existing building.
And Cyrus, it's your understanding that my office filed a witness statement on your behalf in this case?
Correct.
And if you were to continue to testify, that testimony would be consistent with the statements that were previously provided. Is that right?
It is.
Chairman, that concludes our case in chief. We'd be happy to answer any questions you might have about the program.
Any questions from the board?
Where's the 1 new parking space going? I don't see it on the designs.
It's in the off the alley. There's an existing porch which we're rebuilding. So that new 1 parking space is accessible off the alley, and then we're reconfiguring that existing porch and stair.
Commissioner, that would be at, if I have my directions correct, that would be the southeast corner of the property. And that should be shown on the site plan for the program.
Okay, thank you.
Any other questions from the board? Okay, thank you. We will take it under consideration.
Thank you.
Next, we're going to go to 14420Z and 14520Z. This is 1443 West Summerdale. And for this one, we do have objectors. So I won't give you the whole spiel over again that I gave this morning, but just to remind everybody, we'll have the applicant present its case and do its witnesses. Then we will go. I don't believe there is a counselor speaking on behalf of the objectors. So then we'll go and Mr. Luna, if you'd like to speak then on behalf of the alderman, and we'll have the objectors. I'll identify you one by one on the list that I have. You can present your objection. If you'd like to ask questions of the applicant, you can do so. Just identify for me which applicant in particular you're attempting to ask a question of, so we can help our court reporter identify who is speaking. Everybody, for objectors, when you speak, first time you speak, I need your name and your address. And for everybody in general, every time you're speaking, give us your name again, so our court reporter can keep track of who's saying what. And I'll just reiterate, there's no need to repeat something that another objector has already stated. Again, I keep saying it's not a town hall. We don't do anything by community vote, right? So once somebody has made an objection, we've taken that under consideration. So you can just say, I agree with the same basis that that objection was made. You don't need to elaborate on it further. So then,
Mr. Chairman, this is Victor again. We do have one person that's here in support. He's a call-in, but I'm unable to promote him.
okay.
It's Kevin Erker.
Yes. Can you hear me?
Yeah. So he's in support.
Okay, perfect. So then after the applicant presents its case, Mr. Erker will go to you, and then you can add your bit, and then we'll go to the opponents. So then, Counselor, we'll start with you again. If you can identify your witnesses, I'll swear them in, and then you can, why don't you give us the whole presentation since you have objectors?
Great. I have, on behalf of the applicant, Mr. William Pepin, and then on behalf, I'm sorry, our project architect, Mr. Ramil Kanaun.
And I'm sorry, who is the first? It's William Pepin?
It'd be William Pepin, although I do have 3 LLC members, and I do see that at least one has been signed in. I believe William's is available. William, can you hear me?
You're gonna have to unmute yourself, Mr. Pepin.
There we go. Now I can hear you. Sorry.
And do you swear to tell the truth in the proceeding?
I do.
And Mr. Whaling, you're one of the other LLC members?
I am.
And do you swear to tell the truth in this proceeding?
I do.
And then Mr. Kanaun, are you there?
I am.
And you swear to tell the truth in this proceeding?
I do.
And then is it Mr. Luis Manje?
Manje, yes.
And you are also one of the LLC members?
Yes, I am.
And you swear to tell the truth in this proceeding?
Yes, I do.
Okay, Counselor, I think that was everybody on your list, right?
Yes.
Okay, why don't you go ahead?
Okay, thank you. Again, for the record, Nick Fatikas from the law offices of Sam Banks. I'm here on behalf of the applicant, 1443 West Summerdale Partners, LLC. The applicant owns the subject property located at 1443 West Summerdale. The subject property measures 30 feet wide by 125.5 feet deep, and it's improved with a 100-year-old non-conforming 2-story, 2-unit residential building. As I just stated, it's 100 years old, and over time, the existing structure has fallen into a bit of disrepair. The applicant is proposing an extensive renovation and remodeling project that would bring the building back to life as a single-family home. The project plans call for a rear 2-story addition that would replace an unpermitted enclosed porch and an enclosed rooftop access stair and roof deck. The plans also introduce an open deck and stair system at the rear of the home that will provide ingress and egress from the home's first floor, as well as access to a deck proposed above the detached garage located at the rear of the lot. In order to permit the project, the applicant is seeking variations to reduce the east side setback from the required 2.4 feet to 0, reduce the combined side setback total from the required 7 feet to 0, reduce the rear setback from the required 35.15 feet to 2 feet, and increase the floor area total from 3,389 square feet to 3,766 square feet. I do have 2 witnesses, although there are a few additional that are available to testify, but 2 primary witnesses. First, on behalf of the applicant, Mr. William Pepin, and our project architect, Mr. Ramil Kanaun. And with that, I'd ask to call my first witness. William, can you please state your name and address for the record?
Yes, William Pepin, 2921 North Lincoln Avenue, Unit 401, Chicago, Illinois, 60657.
You're the managing member of the applicant, 1443 West Summerdale Partners, LLC.
Yes, I am.
And you, that entity owns the subject property at 1443 West Summerdale, is that right?
Yes,
As I described it, the subject lot measures 30 feet wide by 125 and a half feet deep.
that's correct.
And it's improved with a 100-year-old non-conforming 2-unit residential building, is that right?
That's correct.
Again, you're proposing an extensive renovation and remodeling of the existing building, as well as proposed additions to it.
Yes, sir.
And ultimately, you'll be converting the 2-flat to a single-family home, is that right?
That's correct.
And the issue in this case is that the existing building is already non-conforming, right?
Correct.
And separate from the unit count and setbacks, the rear enclosed porch, which is existing, is not properly permitted.
That's correct.
So you're seeking variations not only to account for the proposed floor area, but also the floor area that you'll be replacing and the open stair system between the home and the detached garage. Is that right?
That's correct.
And is it true that you provided the board with a financial?
Counselor, we lost your mic again.
Oh, I'm sorry. Is that better?
Yes.
Okay. William, is it true that you provided the board with a financial summary for this project?
Yes, we did.
And based on your anticipated costs and anticipated price point, you're projecting about an 11 to 12% return on your total investment. Is that right?
That's correct.
And that gain is very much predicated on being able to permit the proposed scope of work. Is that true?
That's true.
And that's because you'll be making significant investment to renovate literally the entire structure, from reconstructing the home's front wall to reorganizing the floor plates to building a new rear addition to replace that unpermitted enclosed porch. Is that right?
That's correct. For a project to become a viable home in today's market, it needs to meet the current buyer's demands for the configuration and layout of the bedrooms, bathrooms, upgraded amenities and finishes, and the function of the floor plan to include the outdoor living spaces that are required in single family in this area.
You believe the project will be viable and able to meet those marketplace demands if the variations are approved. Is that right?
Yes, sir.
And William, is it your understanding that my office filed witness statements on your behalf in this case?
Yes.
And if you were to continue to testify, would that testimony be consistent with the statements we provided?
Yes. Yes, sir.
Thank you. Chair, my next witness, I'd like to call Mr. Ramil Kanan, the project architect.
Please.
Ramil, can you please state your name and address for the record?
Sure, Ramil Kanan, 1050 West Hubbard Street, Chicago, Illinois, 60642.
You are a licensed architect in the state of Illinois?
That's correct.
You've testified in that capacity many times before this board, is that right?
That is correct.
And you designed the program for the proposed renovations and additions to the residential building located at the subject property?
Correct.
And is it your professional opinion that the existing non-conforming building conditions, including the non-conforming side setback dimensions and the unpermitted enclosed rear porch, taken together, create the practical hardships or particular difficulties in this case?
That is correct.
And is it also your opinion that each of the requested variations is aimed at resolving a specific existing building condition and not solely proposed for maximizing monetary gain?
Correct.
With respect to the east side setback reduction, it specifically allows you to permit an open deck and stair system at the rear of the home's first floor. Is that right?
That's accurate.
And the reason the stair needs to be more than 4 feet in height, and because of that, it becomes a technical encroachment in the side setback, is because the stairs are designed to align with the building's first floor, right?
Correct.
So the existing floor height dimension is 5 feet, and that's an existing building condition you have to work with, right?
That is accurate.
And even though we're asking for a 0 east side setback to permit that staircase, the home's east side building wall, even with the proposed addition, will remain set back over 3.5 feet from the east side lot line. Is that right?
Correct.
And again, the combined side setback reduction is really a function or product of the technical reduction to the individual side setback. Is that fair?
Correct. That's fair.
Even so, the home with the proposed addition will maintain a 2.5 foot west side setback, and again, a 3.5 foot east side setback, right?
Correct.
And those are the identical dimensions to what to the side setback conditions established on the lot today, right?
That is accurate.
So again, the addition, we'll get into it in further detail. It follows the building wall straight back.
Correct.
With respect to the rear setback reduction, it will allow the open access stair to the roof deck proposed above the detached garage. Is that right?
Correct.
And again, you've located the staircase on the lot's east side so that it functions together with the staircase that would serve the home's first floor. Is that right?
Correct.
And again, that became the most functional location for the stair system, and it preserves over 385 square feet of grade level open space. Is that right?
That's accurate.
Chairman, to go off script a bit, we did submit an alternate site plan showing how 2 competing staircases would impact the rear yard. And really what we're trying to get at is the design that's being proposed maximizes the amount of grade level open space between the home and the garage, which in reading one of the objector's letters is a specific concern. So our aim is actually aligned with that concern, maintaining the most amount of open space and not eating up that space with competing staircases. And that alternate staircase plan was submitted prior to the last month's hearing. So I hope it's part of the record and something you're able to take consideration of. Ramil, even though the technical reduction to the rear setback is down to 2 feet, this is important. The home's rear building wall, even with the addition, will remain set back 42 feet, 10.5 inches from the rear property line. Is that right?
That is correct.
And that actual setback on its own actually exceeds the 35-foot technical requirement, right?
Correct. It exceeds it.
So, and our final variation is an increase in the home's floor area total. Is that true?
True.
And that's an issue in this case because the existing structure is actually smaller in scale than most of the neighboring residential buildings on the same side of the street. Is that right?
Correct.
And as we've discussed, we're forced to account for floor area contained in the unpermitted enclosed porch as well.
Correct.
Right? And without some level of floor area increase, we'd be forced to actually lose existing square footage in order to bring the building into full compliance.
That is accurate.
So you've effectively designed a 15-foot rear addition to the original back of the building. Is that right?
Correct.
And that addition was designed, again, in part to replace the unpermitted enclosed porch, but also square off the rear of the home, right?
Correct.
And although the addition would have a larger footprint than what the enclosed porch has today, it'll only extend about 7 feet 9 inches beyond the current footprint, right?
That's accurate.
And it really, with the addition, it'll actually align more with our neighboring building to the east, right?
That is true.
And because there are no windows on that part of our neighbor's building, and because we're still set back consistent with the existing setback condition, there should be no impact to light and air on that side of the lot, right?
Correct.
The same is also true for our neighbors to the west. Is that right?
Correct.
And that's because our addition will effectively match up against a metal deck and stair system that serves the rear of the neighboring building to the west, right?
That's accurate.
So again, none of the variations will deprive either neighbor of an adequate supply of light and air to either of their properties, right?
Correct.
With respect to the floor area increase, in sum, we're adding about 180 square feet of new floor area to the rear of the home's first and second floors, right?
Correct.
And that new floor area will really allow you to reorganize the floor plates and incorporate on the first floor a kitchen and family room, and on the second floor a third bedroom, right?
Correct.
And as Mr. Pepin discussed, you're doing this in order to provide home features that meet the market demands for this type of single family home, right?
That's accurate.
And those features include, again, the kitchen size, the outdoor space, the bedroom count, and the functionality of the kitchen and the family room, right?
Correct.
Separate from the rear addition, you're also proposing an enclosed roof access staircase, right?
Correct.
The enclosed stairs will provide access to an outdoor deck located above the home's second floor. Is that right?
Correct.
And that space will function as any other outdoor space, as another outdoor space for the eventual homeowners to use and enjoy. Is that right?
Correct.
And because the ceiling height of that enclosed staircase is less than 6 feet 9 inches, it doesn't count against the building's height or floor area total. Is that right?
That is accurate.
So putting it clearly, it's allowed without any type of zoning relief.
Correct.
All in, we're proposing to add about 720 square feet of floor area to the existing building, right?
Correct.
That includes, or that total includes 348 square feet of unpermitted enclosed porch that we're replacing, right?
Correct. That's accurate.
And that same total amounts to an 11% increase over the floor area total from 50 years ago, right?
Correct.
And that increase is still less than the 15% increase that is otherwise authorized by the, as a variation by the code, right?
Correct.
I mean, the point is, we're not trying to max out the entitlements for this property or your specific project design, right?
Correct.
Instead, we're working within the allowances and the limitations of the underlining RS3 zoning afforded to specifically existing non-conforming buildings.
That's accurate.
Ramil, do you believe you've become familiar with the neighboring buildings and the pattern of development in the immediate area?
Yes, I have.
And is it true that your own survey confirmed that 11 of the 14 buildings on the south side of the 1400 block of West Summerdale are 3 stories in height, right?
That is correct.
So our home, even with the enclosed rooftop stairs, will still be consistent with the majority of the buildings, right?
Correct.
And that specifically includes both of our immediate residential neighbors, right?
Correct.
Is it also true that 9 of the 14 buildings on the south side of the 1400 block of Summerdale have rear setbacks that are equal to, or actually less than, what our proposed rear addition will be?
Correct.
So is it also your opinion that the proposed building footprint, specifically including the rear addition, will still be consistent and compatible with the majority of the neighboring buildings on our side of the block?
That is accurate.
And Ramil, the screen that's showing right now is that exhibit that you prepared. The red dashed line is the setback that our building will go to. Is that right?
Correct. So the red line that you see there kind of running east to west is the rear setback of our proposed addition. Correct.
And again, your count was 9 of the 14 buildings on our side of the block are either equal to or provide even less than a setback than what we're proposing.
Correct. For what we could inspect visually with the tools we had, that is accurate.
And at the same time, is it also true that the actual grade level retail space, grade level rear yard open space would exceed what many of the neighboring buildings provide?
Correct.
And in fact, your design, when you take it into consideration, the U-shaped apartment building or the building 4 or 5 lots up that extends all the way to the rear property line, you're providing more than some of the neighbors on the block do.
That's accurate.
Ramil, you prepared the exhibits describing the existing block and building conditions for comparison with our project?
That's correct.
And is it your understanding that my office filed a witness statement on your behalf in this case?
Yes.
And if we were to continue to testify, would that testimony be consistent with the statements we provided?
Correct.
And Ramil, specifically, your position, professional opinion and position is that the proposed variations meet the standards or criteria for variations. Is that right?
Correct.
And that the resulting building will still be consistent and compatible with the other neighboring improvements in the immediate area?
That is accurate.
Thank you. Chairman, that concludes the applicant's case in chief. We'd be happy to answer any questions you or the board members might have about the program.
Are there any questions so far from the board?
Yeah, I have a couple. This is Jolene Saul. Specifically for the rear setback, can you just speak to the hardship again, once again, just for the rear setback, and then if that were not approved, what the impact on the development would be?
The rear setback down to 2 feet specifically allows the stair configuration so that people accessing the staircase that would serve the home can also use that same staircase to access the roof deck above the garage. The proposed addition does not require rear setback reductions on its own. Again, even with the 7 foot 9 inch addition beyond what's currently at the property, we're actually well under our requirement. So the technical setback reduction is aimed at allowing the staircase to be a single staircase as opposed to two competing staircases.
Thank you.
And can you just continue along that thought? I mean, the reason now for the hardship on that, why you need the single staircase as opposed to the two, expand on that for me a little bit.
So one of the things that came up during the community review process, and again is memorialized in one of the letters, is a concern for maintaining open space between the home and the garage. And it was just shown, as this is the proposed site plan, this maintains over approximately 385 square feet of usable open space, of backyard between the home and the garage. If, I believe it was Jeanette, if Jeanette can go to the alternate plan, in order for us to provide two staircases, we lose the function and use of that yard space. So we're reducing it, and I think that is contrary to not only the market demands, but also concerns raised by some of the objecting neighbors or the community organization on that point.
Okay. And can you, I'm asking you to repeat yourself now, but for the second variation on the east side setback, can you just reiterate for me again what the hardship is and what's there? I don't think from your findings there was a specific need ascribed to that setback or that variation request.
So the setback, it's actually plays in part with the staircase. We need, even if we didn't connect the staircase from the home to the roof deck, the staircase needs to exceed 4 feet. It needs to go up to 5 feet to meet the first floor building height. So the hardship is actually the existing condition of the existing building that we're trying to provide ingress and egress from. We don't have the luxury of a grade level first floor. You know, we're a few feet above that. Our starting point's 5 feet. And that is in turn, that is the hardship, the existing building condition.
And then on the FAR, your hardship is that your existing structure is already smaller, you said, than the neighboring buildings. And because of the existing, if I understood you correctly, because you already have this existing unpermitted porch, you're basically just trying to bring that into compliance with the extra FAR?
We're going a little bit beyond that, but it's part of our argument. It's really threefold. One, we're one of the few buildings that doesn't have or that's smaller than the neighboring buildings. So we think that we're at a competitive disadvantage with that regard. More importantly, we're trying to reorient and reorganize the floor plates from a 2-flat to a single family home. We don't need 2 kitchens. We don't need 6 bedrooms the way they're lined out like this. What we're trying to do is meet some of the market demands by squaring off the back of the building and replacing the enclosed porch. And in the testimony, Mr. Kanoun explained that we are basically forced to bring about 300, hold on, let me give the exact dimension, 348 square feet of existing enclosed porch into compliance. And we're only going beyond about 160 square feet or 180 square feet per floor plate. So it's part and part, they're tied together is really the point.
What was the extra number? It's 348.
So the addition will be 720 square feet total. 348 square feet of that is the enclosed porch that we're replacing.
Got it.
And what we're trying to do is pick up additional square footage that would otherwise, without the first floor building height, having to connect to the stair, we're nowhere near our rear setback requirement. We're just trying to infill what would otherwise be a buildable area on the lot. Because again, the rear of our building exceeds what would the technical rear setback reduction or the technical rear setback on the lot.
Got it. Okay, any questions at this point from the board? If not, then Mr. Erker, I'm going to go to you if you'll give us your name and address.
Hello, thank you very much for, my name's Kevin Erker, 1469 1469 West Summerdale. I'm a neighbor on the same side of the street.
And before you continue, do you swear to tell the truth in this proceeding?
Oh, yes, I swear to tell the truth, yes.
Okay, then go ahead. You're speaking in support of this application?
I am speaking in very strong support of the application. I have a single family home. I agree with the discussion about the market demands. My neighbors directly to the east of me, it was a property developed after we purchased our single family home. That was at 1467 West Summerdale. They have this same staircase configuration. They have the garage deck. My neighbors across the alley on Berwyn have the deck. We have the deck. Everybody has the deck. There's a community there. Everyone is needs that kind of outdoor space, especially in this circumstance. And we're very, very much in favor of course, safely, but expeditiously having a family move in. And we do think that I reviewed the setbacks myself and can say they would be comparable to what I would expect. And the truth is the property now is very dilapidated and abandoned, just like 1470 Summerdale had been. And, it honestly, it's an attraction we have a homeless problem around. And, I've spoken with some of the people that go into these abandoned buildings. So we need to, for the sake of the strength of the community, build this out, get a single family home that's consistent with the characteristics of the neighborhood, which this would be. The property's in real bad shape now, and the market is what it is. But yes, me and my wife, our daughter, we're about to have another daughter in 2 weeks. We very much strongly support this. I won't go repeat, but again, the rooftop deck and stair configuration under consideration here is standard. We have it. Our neighbors across the alleys have it. Everyone has dinner outside. We talk. We're friends. So I would just say again that the property is in very bad shape and it's abandoned, and we would love to see a family set up roots in the community as well. So that's my perspective.
And I'm sorry, Mr. Erker, I know you gave me your address, but how close are you to this proposed development?
So the proposed development is 1443. We're 1469. So it's a few buildings down. There's a series of multifamily units between us. I'm one of the, kind of small number of single family homes. So I'm in particular interested in this conversion. We think that, single family homes are more likely to bring families that will stick around for a long time, send their kids to Pierce, send their kids to Senn. I know there are objections from the EARC and maybe even Dan Luna, but I just ask, are we looking at a situation where we're going to make our community stronger, where we're going to build a single family home, where we're going to have a family invest, and even for the city where we're going to collect more property tax? So for me, it's a win-win-win across the board. And what's being proposed here is consistent with the other developments around, and, strongly in favor of it.
Thank you. Are there any questions from the board of Mr. Erker? Okay, thank you. So we're going to go next. Mr. Luna, are you there?
Good morning, Chairman.
Good morning. Do you want to present your opposition now or after the others?
Sir, I wouldn't mind saying a few words if that's okay with you and the board.
Sure. Do you swear to tell the truth in this proceeding?
I do.
Okay, please proceed.
Good morning, Mr. Chairman and members of the ZBA. My name is Dan Luna. I am the Chief of Staff for Alderman Harry Osterman here in the 48th Ward. We have been in office since 2011, and our process since then has always been the community process. We have done this for all zoning changes and variances throughout our community. The developer and their team have met with the neighbors and the Block Club, the EARC Block Club, which stands for the East Andersonville Residents Council Block Club, and their zoning committee. Unfortunately, the neighbors and the zoning committee do not support this request and have sent letters to the alderman showing their opposition for this request. And for that reason, Alderman Osterman does not support the variances requested for 1443 West Summerdale Avenue. That concludes my, my talk, Mr. Chairman.
Thank you, Mr. Luna. Are there any questions from the board? Okay, then we are going to go to Christopher Modoff. Are you there?
Yes, I am. Can you hear me?
I can. Do you swear to tell the truth in this proceeding?
I do, Mr. Chairman.
Okay, then if you could give us your address and then go ahead and give us your opposition, please.
My name, like I said, my name is Christopher Modoff. I live at 1443. I'm sorry, 14. I'm stuck on 1443. 1435 West Berwyn. I own the entire building, but I live in Unit 2.
Okay.
Mr. Chairman, thank you very much for the opportunity for able to speak to you and your committee. I am the chairman of the ERAC Zoning and Appearance Committee. Our group worked very, very hard a year and a half ago to downzone this neighborhood, East Andersonville, to R3 from R4. And our main goal was to stop developers from coming in, taking over a building, and building it to the maximum capacity that they possibly could. Our goal in that process was to save green space, to save architecture, and to keep the neighborhood the way that it is right now, the scope of the architecture in the neighborhood. We were able to downzone this neighborhood a year and a half ago to R3. And these variance requests are an attempt to bypass that zoning downgrade, in our opinion. If you look at what they're doing here with this building, they are going in 4 different directions larger. They are extending the front with a building all the way to where the stairs go up. They are extending this building on either side, and they're extending the building in the back. I know the architect talked about how the building itself now would go back and would be in alignment with the neighbors on either side. That is incorrect with the neighbor on the west side. If you look where his building would go out to at this point, it goes up to where the stairs go up to the decks on the building next door. That area would lose sunlight because their decks are behind that staircase. So there is sunlight loss to the neighbors on the west side of the building. Both neighbors on either side of the building came to us and said that sunlight was a very important thing for them on their deck space. This would take away in the front, in the back, on the east, on the west side of the building. They're also proposing going forward with this building, as you can see on your proposed site plan there. What they fail to mention there is that the building just to the west also has front decks on it, okay? And those decks on all 3 levels would also have sunlight loss as well. So our major objection, and we tried working with this development group, we had numerous meetings with them. We were more than willing to, we understand the decks in the back, then that's the new trend in the neighborhood and how there are some on that block. We understand that. And what we tried to do was go ahead and give them their variances on the side and give them their variances in the back. But what we appealed to them was to try to keep the facade of the building, to have the building keep in a look of Andersonville. And their plans do not do that. We actually put a proposal out to them where we had a masonry contractor come in. They kept telling us that it was too expensive to do that and to keep the front facade. We had a masonry contractor come out and give us an estimate on what he thought that the cost would be to maintain the original facade of this building. And they wouldn't even look at our proposal. All right, we still have that. If they're willing to look at it, more than happy to do it. It comes in for under $20,000. That's less than 2% of what they're going to sell this building for. The other thing is they talk about how there's our major objection is the FAR going from 0.9 to 1.0. This is exactly what we fought against, was this type of developer. And keep in mind, this developer and the 2 gentlemen that they had talking, none of them live in the neighborhood. All right, Mr. Chairman, what these guys are going to do is build a building and then sell it. And they're going to leave the neighborhood. They are not part of the neighborhood. We are excited to see a new building here. Don't get me wrong with this. We are in agreement that the building is not in good shape. We are in full agreement that we'd love to have a new family come in. We are in full agreement of upgrading this property, but we'd like to keep it within the rules that we fought so hard to get a year and a half ago when we downzoned from R4 down to R3. And they can talk about all they want about extra space and how they're using non-conforming space already. At the end of the day, they're asking for an extra 372 square feet. And that is 100% for profit is what it is. And like I said, we went to them and tried to have a negotiation, say, hey, if you would keep the front facade, we'll give you your 2 variances in back. But my committee and the neighborhood, and keep in mind, I run the committee for EARC. We are the neighborhood organization for this neighborhood, the center where this is going to be. And our members were stringently opposed to allowing an FAR increase from 0.9 to 1.0. We feel if you allow this to happen, you're setting a precedence for this neighborhood. Keep in mind, this is the first case that has been brought up to you since we rezoned to the downside. So any variances that you request or you grant this group, you're setting a precedent for any future variance requests going forward in this neighborhood.
Any, let me actually, I want to just clarify a couple things, or asking clarifications on a few things. So I'm using as a little bit of a reference, there was a letter that was sent to us. I don't think it was the official one from the EARC, but it was from Leslie Ames as a block rep of the EARC. Are you familiar with that letter?
Yes, sir. I'm sorry, I can't hear you. Someone has a lot of background noise.
How about now?
Okay, that's good.
Mr. Valenziano, did you have something?
No, sorry.
No worries. Counselor, do you have that that photo and that letter? It was part of, I think, the original objections from prior to when this matter was continued. I think you should have it or have it somewhere.
I believe so. I have the board of directors letter from EARC. Is that the one you're referencing, dated June 19th?
No, there's a March 9th letter from a Leslie Ames.
I believe it's referenced in that same letter, Chair.
Yeah, that's the one. It has a picture in the back. I just want to make sure. So I want to make sure I understand the arguments about sort of light and whatnot. So this is the view from whatever direction that is, sort of highlighting what it looks like in the rest of the area. And so the concern, if I understand correctly, is that and this is to Mr. Madoff, the staircase being as tall as it is, which the applicant is saying is a necessity because of the existing condition and the existing height of the first floor building, I think, or the first floor access. The argument is that staircase and the bulk of the staircase is going to sort of block light. I think you said to the 2 immediate neighbors. Is that?
No, sir. I was talking about there. If you go back a couple slides on how the back of the building, the back of the structure of the building, bring it up with the neighbor, with the ones comparing it to. There we go. So if you pull this out all the way to their full, they want to go past the non-conforming another 7.9 feet. Okay. So that line that's right there, they claim that matches up with the building that would be west, just to above on this picture above. What that matches up with, sir, is the staircase that goes up. Okay. And if you pull the picture of the building from the back, by putting the building out that far, actually will cut off sunlight to the decks on the back. See how this picture, see how that's a staircase, and then see how the decks are right there. So if you pull that building out, they're going to the edge, all the way to the edge there of where the beams come up to where the stairs are going up. So you're cutting off sunlight there to those decks that are all back there.
Can I interject for 1 second?
Sure. You got
So is our understanding that the sun sets to the east?
Hold on.
No, there's a lot of people that wake up and want to drink.
One at a time. So Mr. Canaan, I need you to identify yourself again before you speak.
Ramil Canaan, project architect for the 1443 project.
Can you repeat your?
I understand Chris's position, but we are to the east of that area. So unless the use of that, yeah, will there be a potential block of that in the early morning hours? Of course, but for almost the remainder of the entire day, that deck will have sunlight.
And this is Chris Modoff again, and the neighbors who object to the building going back that far that live in that building all tell me that they like to go out in the morning and read their coffee and drink their coffee and read the paper out there.
Chairman, it's Nick Fatikas, and if I could interject, I think the photo speaks for itself. The closest building feature our neighbor has is a metal stair system. The decks are further away from that. So to Ramil's point, again, you're looking at if there is any type of new shade that's caused, it would happen on the staircase and further into the building where the decks are would remain unobstructed. I'd also point out on the other side of the property, not only are there no windows along the shared lot line, there's also a privacy trellis. So it's not, our position is that we're not going to create or impair an adequate supply of light and air to adjacent properties. Will there be maybe a little bit more shade on the staircase to the neighbor to the west? It's possible, but does that amount to an adequate supply or an inadequate supply of light and air? Absolutely not.
This is William Pepin, if I can speak for a second.
Go ahead.
We brought up earlier in the testimony that the required rear yard setback here is 35 feet. So the code anticipates all the buildings on these lots in this zoning district being allowed at 2 stories of height, the 30 foot of height, to be extended back to the 35-foot point. We are stopping at 42, so we are 7 foot shy of that. If we were to honor ERC's request and save the front facade of the building, we would extend it all the way back to the 35-foot line. So the situation would be even more detrimental if we believe it's detrimental today. And I can do that by right. I don't need anyone's permission to do that. So we are trying to be sensitive and balanced in our approach here and trying to create as much open space and usable space at the rear of the home with the rear deck and the rear yard and the roof deck to make this attractive to families to move into the neighborhood.
Mr. Pepin, will you repeat that again, what your argument was with what you can do as of right and why that would be worse?
I couldn't hear you, Chairman.
I just want you basically to repeat what you said about what you can build as of right and why that would be worse.
Well, as of right, in the zoning district, the rear yard of the house can be 35 feet. We have a rear yard of 42 feet. So we have kept 7 foot of open space at the rear of the house that is not required by right in the code. Admittedly, we're asking for a slight addition of square footage, but we're doing that by bringing the front of the building by right to a more logical position relative to the street, and then putting the most modest addition possible on the rear of the house, trying to be sensitive to all sides of the house, not just one side.
Got it. Okay, I want to go to Julie Walk, who is also, I think, in opposition. If you will identify yourself for me for a second.
Well, you have to. This is Julie Vlach. That's spelled W-L-A-C-H, and I have submitted written comments as the ZBA has requested, and I will focus on the front yard. I'm going to focus on that because Mr.
Ms. Block, I've muted you for a second. I need both your address and I need to swear you in. So.
Oh, I'm sorry.
Swear to tell the truth in this proceeding?
I do.
Okay, and if you could provide your address for me?
5245 North Glenwood.
Okay, now please proceed.
Mr. Modaff mentions and focused a little bit on the front, and he called it decks, but the adjacent property west, 1445 Summerdale, has a front porch. These two buildings have facades and fronts that were very similar. And what the developers want to do is destroy the appearance of the front of their building instead of utilizing it as an appealing factor for a single family home. We're very pleased that they want to do what they want to do in terms of rehabbing a building into a delightful single family home. But to push out the front and eliminate the front porch puts it in line with it's a quirk in the way the zoning calculation is on buildings farther away, but the immediately adjacent building 1445 will lose all the sunlight in the front. And as to comments about sociability and everything, we all sit on front porches. And this front porch will be virtually eliminated, commissioners and Chairman Prang, by a wall, a solid brick wall with windows, of course. It'll have a small stairwell, and that's it. There's no structure aspect to this structure that they propose that will encourage interaction with the neighborhood, that will be encouraging. We have many, many young families in this neighborhood. And in fact, Mr. Erker has a lovely front porch in his front yard, but that will be eliminated. And the inability and unwillingness of these developers and their architect and their attorney to go back and reconsider our requests regarding that front facade. And as I said in my analysis, whether they do, they can use that existing front facade, that existing front yard setback, and still build a building that is highly marketable. We have a number of single-family homes that have been converted from two flats, such as this one, a little larger footprint, but they are enlarging the footprint in the back. And they will find that they will be able to, market this very successfully and not damage their return on investment. In fact, if they followed our suggestions and rebuilt or reconstructed this structure consistent with the housing environment and the structure next door to it and other structures throughout the area of East Andersonville, they would find that it'll probably be even more highly marketable than the uncharacteristic, hostile front wall that they intend to put on this building. And finally, as to all this business in the backyard, they originally on their plans have a two-car garage. This is a 30-foot wide lot. There's ample space on one side of that garage wherever they decide to build it, because there isn't any garage there right now. There's ample space, commissioners, for them to build a stairwell access to a garage rooftop. And this, what they envision here is a rooftop deck on the building, a rooftop deck on the garage, and no front porch, a hostile walled exterior along the street side, the facade of the building. And this is not neighborly. It's not conducive to young families interacting with the neighborhood. Where I live at 5245 North Glenwood, I'm just around the corner, and my interest comes from the fact that I'm keenly up the learning curve about what we did to downzone this neighborhood to R3 and Y. And on my block, we still all have our front porches, and we've got half a dozen families with little kids, and they'll sit out and we'll sit out and we'll walk by and say hi to each other. So many of the objectives that Mr. Erker mentioned, or that the developers and their attorney and architect mentioned, are beyond insensitive. They are inconsistent and financially out of line with what would be the most successful development for this property.
Thank you. Are there any questions by the board of Ms. Vlock?
Yes, I'm here.
I'm just
Hello.
Yes. Can you hear me?
I can.
I'm just inquiring of the other commissioners if they have any questions specifically. And it looks like they don't. Okay, any questions generally so far from the board? Okay, Counselor, can you just orient me for a moment? There's, as you mentioned, there's a proposed and then an alternate site plan that's part of our record. So I follow on in the alternate site plan, I follow, I think, what you're doing in the backyard, where you're not connecting the staircase anymore, and your argument is it's actually worse for the open space in the rear yard and sunlight, et cetera. In the front yard, are you removing, in the alternate plan, you're removing the what Ms. Vlach is referring to as the sort of hostile front portion of that building? Is that what that shading is?
So what we're doing is the building, as we stated, is in a state of disrepair. There are some foundational issues. The front building wall is it's in bad shape. So what's being proposed is a partial front addition that brings into compliance, or that rebuilds the front wall. The front wall, though, on its own is permitted. We're not asking for front setback relief. It's part of our overall program for the property, but it doesn't trigger on its own front setback relief. It's code compliant with that regard. Again, we appreciate Mr. Madoff did send over a suggestion for alternate plan. The issue is the front facade, we don't believe can be saved. It is in very bad condition, and the cost involved for attempting to save it, it doesn't work. It's not a viable option. I think Ramil may be able to speak to that more directly on that existing condition of the front.
And is the, before he does that, so you're staying within the existing front setback then, or the front line as it currently is, but you're closing off, I guess, the porch. What are you actually doing to it when you're bringing it sort of up to code?
It'll have, I think the one neighbor said it'll be more of a flat wall, and it'll have windows. It's not a brick. It's not just a brick wall. I mean, it's not going to look like a fortress. There will be windows, and it'll be a new masonry front wall. And Ramil, if you want to add, turn the floor over to you.
I mean, to answer the question in regards to the existing front wall, we performed a visual inspection of that on site. The existing masonry, as Nick said, is in major disrepair. There are step cracks, there's settlement, there's water infiltration issues within the basement, foundation issues, just a slew of problems that would need to be remedied. To talk about the quote that they received, I'm not sure where or what the basis of that cost was, because to salvage that front at $20,000 just does not seem reasonable. If that's a tuck pointing cost, potentially, but to restructure the existing roof structure of that front porch, address the foundation issues, address the masonry issues, replace segments of stone on the front, that well beyond exceeds a $20,000 repair bill. So I'm not sure as to what the basis of that quote that the neighborhood group received is on.
And in the alternate plan, are you doing the same thing in the front?
Correct. The alternate plan has no difference for the front. The facade is consistent for both.
It's just shaded differently is why, that's what I'm trying to confirm.
Yeah, correct. There's no difference between them though.
Okay.
And this is Commissioner Garcia, the sides of the building remain the same?
Yeah,
Is
correct.
the alternate, so the front and the sides, the only thing different is the stairs.
That is correct.
Okay.
And just for clarification, are there other buildings on the block that do not have front porches?
Correct.
Yes, including one of our immediate neighbors, the 3-story multi-unit building. If you go back to the front photo, to the left, there's no open porch. There's a bay that's part of that building. That is quite typical of the multi-unit buildings that are up and down the block, which is the majority of the buildings on the block. And again, that exhibit was prepared by Ramil and included in our compiled exhibit set. And you can just see from the aerial, the larger multi-unit buildings don't have front open balconies or porches on them.
Thank you.
And to go back to the sides one more time, so the front of the facade of the building is going to be no longer, you're building a new facade within the existing front setback requirement. There's no variance for that.
Correct.
In the back, you don't need a variance for the rear setback, and you're demolishing the existing enclosed porch that was unpermitted and rebuilding it and adding, are you demolishing or changing the sides of the building?
No, well, what we're doing is we're taking, if you look at actually the site plan that's shown right there, the 15-foot demarcation for the addition ties in where it begins on the back of the building is the original back of the building, not including the unpermitted enclosed porch. If you look, we're trying to follow that existing building wall line on both the east and west sides of the lot straight back. We're not creating a larger encroachment or more of an encroachment into either side setback. And specifically with the rear setback reduction, the rear setback reduction specifically allows the stair connection and the rooftop access stair to the garage roof deck. The rear of our building will remain 42 feet, 10 and a half inches from the rear property line. The technical requirement is 35 feet. So again, we're 7 feet shorter purposely than what would otherwise be allowed for the technical rear setback of our building.
And
If
for
you were
the-
to build new, you could go 7 feet further back.
And from the front, are you on, it looks like you're on the 30-foot setback from the sidewalk, is that, am I reading that correctly? The new building would come right to where the setback requirement is?
Correct. That's just the allowed front setback, correct.
Okay.
And again, we're not asking for front setback relief. I want to make sure that's clear. That's not part of our program.
Mr. Commissioner, if I may.
One more question on that. On the front setback, is that in alignment with the other properties? So it's basically coming, I get that there's no request for a variance there. But so the front of the new facade of the building would be aligning with the other fronts of the building on the block? Or kind of what's the character of the neighborhood of where those facades are?
It is, and Ramil, the site plan that's showing has both of the neighboring buildings so that there's some level of context just in the footprint of those structures compared to what's being proposed on our lot.
Correct. It's based on the average.
Okay.
So we're meeting that average. Is the commissioner's question, we're meeting that average.
Correct. And it's actually, this street is somewhat of a unique situation where that property line where you see kind of at the end of that stair, on that block of Summerdale, a majority, almost, if not all of the properties have fences and yards built out that kind of extend out to that sidewalk area. So we were also somewhat confused when we first did the site plan because we assumed that the site went further beyond, and it didn't. Property line is actually set back, but almost all of the buildings have a front build out all the way out to that sidewalk. So you'll actually see enclosed and vegetated areas fenced off and running all the way up to those walkways.
Mr. Commissioner, if I may.
Yeah, go ahead, Mr. Maddow.
A couple things, and thank you very, very much, Alderman, for your questions. If you pull up that photo again in front of the buildings, what they look like in front. Perfect. That's perfect. As you can see, the building on the right-hand side there, which is to the west, their new proposal would come all the way to where those steps start to go up the old building, okay? So you're talking about that building coming out and being all the way out to where those steps start right there. So all of the porches there to the building on the right are going to lose sunlight that have that there, all right? And again, I'm more than happy to send my proposal for the masonry work over to this group. They chose not to even want to see our work on this. My other question to the group would be this. If you're so concerned about the brickwork and everything else and how unsafe and unstable the front of the building is, why are you still able to use the existing building's sides if there's such a problem in the front? I don't quite understand why there's such a problem in front and you don't have the same problem on the sides if you're going to keep the sides. And again, we were more than willing to try to work with them to give them some of the variances in back when it comes to the back deck and things like this, if we could keep the facade. What you're talking about here is a flat building with 6 windows on it and steps going up to that with straight masonry. If you took a picture of our neighborhood, that's not what it is. The other issue here, guys, at the end of the day, is the strict FAR. They want an extra 372 square feet. And again, if you give them this, you're setting a precedence for the neighborhood.
Okay, so I just want to point out formally, we don't set precedent at the ZBA, but I do want to unpack a little bit. Again, we got into this a little bit, but I want to just make sure I follow on the FAR increase. So there's a portion of it that's not really a new additive. I think we said it's 348 square feet for the porch.
Correct.
The rest of that, the difference between that and 720, can you, Counselor, kind of articulate for me again where that's going? It isn't
Right, so yeah, it's spread out in about 180 square feet on the first floor and then on the second floor. And on the first floor, it'll be used to provide or to better organize the kitchen and family room. And then on the third floor, or the second floor, I'm sorry, it'll be a 3rd bedroom. And those were articulated by the architect as well as obviously shown in our plan set. And those are intended to meet, obviously the needs of a multifamily 2-flat are different than a single family home. So what we're trying to do is work within the footprint, work within, again, what today functions as 2 identical footprints and reorganize them to function as a single family home.
And that 3rd bedroom is really in the back anyway, it looks like.
Correct. And that would be the 3rd bedroom on the 2nd floor. There are multi-purpose and bedrooms in the basement, the rec room that's showing. But that would be the typical 3rd bedroom on the 2nd floor, above grade.
Great. Okay, any other questions from the board?
Here, would I be able to briefly conclude?
Yeah, please.
Thank you. We heard a lot about the down zoning and the maximization of what's being proposed. The down zone on its own from an RT4 to an RS3 does not preclude a homeowner or a developer or any other applicant to seek an FAR increase for a non-conforming building. It's actually allowed by the RS3 zoning. We're not trying to obviate the RS3 zoning. We're trying to work within the new parameters and restrictions that are imposed by the RS3 zoning. We stated that we're asking for an 11% increase in floor area based on the total from 50 years ago. The code allows for a 15% increase. We're not maximizing. We're asking for less than what could otherwise be sought. The light and air issues I think we've discussed. I want to be sure, I want the board to be sure the current west side setback on the building today is 2.5 feet. We're maintaining that. The current east side setback is 3.5 feet, and we're maintaining that. The proposed rear setback with the addition is still 42 feet, 10.5 inches. It's more than 7 feet beyond what's required. We're well within the allowance with respect to the rear setback. The argument that the variations are being sought only for pure profit is patently false. The code says that you can't ask for a variation solely for the purpose of getting more money out of the property. By its very nature, at least part of our request is aimed at bringing an existing non-conforming building feature into compliance. In this case, taking down an unpermitted enclosed porch and regaining that square footage into the property. It's an extensive project. We're basically hitting the reset button on the building, keeping the frame as best we can, and working within that footprint or that framework. We need the additional square footage to be able to meet the demands of the marketplace. And in that context, we'd ask the board to consider the rest of the block. The rest of the block is comprised of multi-story, multi-unit buildings that are bigger in size and scope. That's what we need to be compared to. And given that comparison, we're still smaller. We think we can make it work. We think the project's viable, but we're not asking for anything more than our immediate neighbors or neighbors on the block already have. And with that, I'd close and ask for a favorable vote on the variance request.
Any other questions from the board? Okay, thank you all. We will take it under consideration.
Thank you.
Thank you.
Thank you.
Next up, I think we're doing a continuance on 162, it sounds like. The applicant for 162 here.
He was signed in, Chair. I don't see him
Okay.
anymore, but I did speak to him. I spoke to his representative. He was not prepared to go forward today. So whatever date you want to assign him.
Let's do August for this one too. We'll do August 21st.
Okay, and for 159, I still don't have an applicant. I don't know if you want a DWP or continue.
What was the original application date for this one?
This was last month, and
Oh.
it was an aldermanic continuance. She did acknowledge receipt of the invite, but she neglected to sign in today.
Okay, did we find Mr. Schroeder?
Yes.
Why don't we do that one? And if the applicant for 159 shows up, we'll do that. Otherwise, we'll continue that one.
Okay.
So then we are going back to 243. I'm sorry, 242. It's 24220Z at 3763 North Sheffield. Counselor, when you're ready, I think we have all your witnesses. Counselor, are you there?
Can you hear me, Mr. Chairman?
We can.
Thank you. Thank you for your patience and thanks for Victor's help in getting Mr. Schroeder on board here. This is a project in the 44th Ward at Grace and Sheffield, a block north of Wrigley Field. The applicant was building in the process of building a 40-unit TOD type 1 project with affordable on site. When the applicant came to know kind of through the alderman's office that the additional building to the south, which was in bad shape, might be available to add to this project. So they went back to the community and did another type 1 zoning change, added another affordable unit, and seek to add these 10 units to the 40-unit building to make it a 50-unit building. And design-wise, and the architect can speak to it, but it basically, this would be the kind of the other bookcase on a somewhat modified but classic U-shaped building. So at Grace Street, the building comes all the way out to the Sheffield sidewalk, and this would be the other end with kind of a courtway in between. As I say, they went back to the community. We have in our exhibits, meeting exhibits, a updated letter from the East Lakeview Community Group, and also the property owner immediately south. We have a specific letter from him approving and supporting the project. And the design was modified to accommodate the building to the south. In our exhibits, our meeting exhibits, you can see the building that was there was on or over the lot line. We have some aerials that show that. And so the new building has a 31-foot by 3 feet setback in the middle of the building to accommodate any windows on the building to the south. And with that accommodation, the building to the south has supported it along with the community and the alderman. So the result is a 50-unit building, TOD, all type 1. And we're here to, what happened was the 40-unit building was all in a B district. But when they took the additional lot and it put them next to a R4 district, and that's what creates the setback requirement, 5 feet in the front and 2 feet on the side. They maintain the 30-foot rear yard setback, and the building is really the lot is 120 feet. So the building, the 5 feet that the building is pushed up really is the same 5 feet that if it was a standard 125-foot lot, you could be another 5 feet back. You wouldn't need the variance. And that's done to maintain the 30-foot setback in the rear. With that, I would ask Brian Schroeder, you're one of the owners and managers of the LLC, is that right?
Let me, Counselor, I don't think I swore anybody in. Mr. Schroeder, do you swear to tell the truth in this proceeding? Are you there? Mr. Hornoff, I saw you're there, right?
Yes, yes, I am.
You swear to tell the truth in this proceeding?
I do.
Mr. Lerner, you're still there?
Yes.
You swear to tell the truth in this proceeding?
Yes.
Mr. Schroeder, are you with us by any chance?
Hey,
He's close to a millennial. I don't know why you'd have all these problems.
speak. They're asking for you.
I think we got it. Mr. Schroeder, are you there?
I'm here. Brian Schroeder's here.
Good, thank you.
Okay. Swear to tell the truth in this
So,
proceeding?
so the chairman has just sworn you in, is that right?
Hold on, Counselor. Mr. Schroeder, do you swear to tell the truth in this proceeding?
Yes.
Okay, Counselor, go ahead.
Thank you. You're one of the managers and owners of this LLC, is that right?
Yes.
And I just told the story. Did you hear me tell the story of how this happened and why we're asking for the transitional variances on the south end of this building with the 40 units? Now you're adding the 10. Was all of that I just said correct?
Yes.
And you've been through several community meetings when you did the 40 unit building, and then you went back to the community when it came to your attention that the additional lot would be available and you were already building the 40 unit building. And you got the community approval again for the addition, is that right?
Yes.
And then also the most affected building, which would be the building to the immediate south, you have made accommodations in your design to create a window well of 3 feet, a 3-foot setback, plus you were already about a half foot off the lot line, that goes 31 feet. Is that right?
That's correct.
And that's to give the building to the south light and air where all of its windows are. The only places that you're closer is where there are no windows, just a blank wall. Is that right?
That is also correct.
So with that, the owner to the south has given a very specific carte blanche support, and where he explains that and says he appreciated the accommodation, and with that, he supports the project. Is that right?
That is also correct.
Okay. And you and I went all through all the criteria necessary for this board to grant the variances requested. And if you were to continue to testify, you'd testify consistently with that affidavit, that statement. Is that right?
Yes.
If I may, I call Mr. Hornoff.
Please.
Yes.
Yes, sir. So you've been involved in this throughout, first doing the 40-unit building and now adding the 10 units. Is that right?
That's right.
And you've complied with all of the various ordinances and building codes, and this building will comply completely except for this 5-foot and this 2-foot variance we're requesting. Is that right?
That's correct.
And you and I went through all of the criteria necessary for this board to grant the variances requested. And if you were to continue to testify, you'd testify consistently with the statement you have on file. Is that right?
That's right.
That's our primary case in chief, Mr. Chairman. We have another owner, Mike Lerner, available, and the architect and Mr. Schroeder available for questions.
Any questions from the board?
Could we just hear once again, if you already did provide it, what the community and aldermanic feedback on this matter was?
Yes, in your meeting exhibits, you know, the chairman always says that you have to, we reloaded exhibits a week ago Monday. And in those exhibits, there is a specific dated, in the last couple of weeks, letter from the community group, which has heard this now twice, and then a specific letter from a Mr. Rob Cataldo, Cataldo, and that's in your exhibits, and where he goes through, he is the neighbor, the owner to the south, and that he appreciates the accommodation of the 31 by 3 cutout window well, and that reflects or kind of fits with his property, and that he supports it as well. So there was a community meeting, a year plus ago when the first project was, and then they went back to the community a couple of months ago with a letter dated in the last couple of weeks, and then the letter from Mr. Cataldo is dated in the last couple of weeks as well.
Thank you.
Any other questions on the board? Thank you. We'll take it under consideration.
Thank you very much.
So I believe our last one was 920S.
If the person who signed in is 475574, can you unmute yourself and identify yourself? We're looking for Annette Akins. Annette, I don't know if this is you or not. Okay, Chairman, there's no response.
Okay, so 15920S, we're going to continue until August 21st. Again, August 21st, no further notice will be given. I move we convene in a closed session pursuant to sections 2C4 and 2C21 of the Open Meetings Act for the purposes of considering the evidence and testimony presented in open session, and to conduct our semi-annual review of the board's closed session minutes. For those viewing by live stream, we will return from the closed session and the live stream will continue at that point. Commissioner Toya seconds, Commissioner Garcia,
Yes.
Commissioner Saul.
Yeah.
Commissioner Esposito,
Yes.
Commissioner Toya.
Yes.
Chair votes yes. We are convening in closed session. Okay, I move we return to open session. Before we do that, let me just make sure our court reporter is ready. Good, perfect. I move we return to open session. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye as well. We are back into open session. We have conducted our semi-annual review of all closed session minutes and made a determination that the need for confidentiality still exists as to all of those minutes. We will now vote. Note that any motion to approve a special use will be tied to the recommendations of the department and any additional conditions read by me. I move to approve board calendars 23919S and 24019S. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 22720S. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve board calendars 22820Z and 22920Z. Commissioner Toya seconds. Commissioner Garcia.
No.
Commissioner Saul.
No.
Commissioner Esposito.
No.
Commissioner Toya.
No.
Chair votes no. Those matters fail. That motion fails. I move to approve 23020S. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 23120Z and 23220Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 23320S. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes. I'm sorry.
Commissioner Saul.
Yes.
Commissioner Garcia. Or sorry, Commissioner Esposito.
Yes.
Commissioner Toya.
Now, yes. Sorry.
That matter is approved. I move to approve 23520Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 23820Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 24021Z and 24120Z. Should be 24020Z and 24120Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Esposito.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 24220Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Toya.
Yes.
Aye. That matter is approved. I move to approve 24320Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye. That matter is approved. I move to approve 24420Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye. That matter is approved. I move to approve 24520Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye. That matter is approved. I move to approve 19220Z and 19320Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye. Those matters are approved. I move to approve 19420Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye. That matter is approved. I move to approve board calendars 14420Z and 14520Z. Commissioner Toya seconds. Commissioner Garcia.
No.
Commissioner Saul.
No.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote no on those matters. On a 3-2 vote, that motion fails. I move to approve the written resolution containing findings of fact consistent with the votes of the board for board calendar number 5520Z. Commissioner Toya seconds. Commissioner Garcia.
Yes.
Commissioner Saul.
Yes.
Commissioner Esposito.
Yes.
Commissioner Toya.
Yes.
I vote aye. That motion carries. I move to approve the written resolutions containing findings of fact consistent with the votes of the board for the board's June 26, 2020 special meeting, with the exception of board calendar numbers 12120A, 22020Z, and 22120Z. Commissioner Toya seconds, Commissioner Garcia,
Yes.
Commissioner Saul,
Yes.
Commissioner Esposito,
Yes.
Commissioner Toya.
Yes.
I vote aye, that motion is approved. I move we adjourn the meeting. Commissioner Toya seconds, Commissioner Garcia,
Yes.
Commissioner Saul,
Yes.
Commissioner Esposito,
Yes.
Commissioner Toya.
Yes.
I vote aye, that motion is carried and the meeting is adjourned. Thank you very much, everyone.
Thank you.